57. Supplementary. I we may not for a week's time to file it. Otherwise, ready we can file it by March.
Anyone for the petitioner? The request of Mr. B. Gogoi, Standing Council, SSA. Matter stand adjourned for 2 weeks, enabling him to file counter affidavit. Mr. N.J. Gogoi is for the petitioner, does not. Yes. 12. Yes. After 12, after 1 week, the joint request.
Otherwise, they should not be reached.
After 1 week, on 28th.
Yes, madam, I don't know.
May I give the also? Why not I back to mention for a definition which is pending. Your notice was issued on 24 page 1923. So may I give that the matter will be taken up on the last part of the Friday or Monday meeting?
Right, 28. 28 lines.
Thank you mention matter, pending matter, admission, because they to my lordship's opinions.
30.
Next one, item number 4, Major. Kindly part of the
Right.
Major, my signal is out of decision. I have taken the question of the other statement.
Your name,
I am pushing.
your mother petitioner.
Yes, Major.
The request of Mr. M. Hussain matters and the general one.
Most of it.
For listing of a new matter for listing,
When did you file it? When did you?
8 years.
It will come on its own.
Come on 11, actually, for an adjournment that day. It was directed to be listed after a week, so any date in the next week.
30.
Next week,
Next week, 25.
I give to mention item number 15 and 16.
Yes.
In 16 and we are for the petition of Mother. We are taking consent of maybe taken up.
At the request of Mr. 15 and 16 is 2015 matter.
15 and 16 member.
Item 15 is 2015 matter. Who is appearing for the other side?
I have taken a consent matter.
Or their consent is irrelevant, 2015 matter. You call them. You call them, you ask them to be present here.
Another pair, similar pair, item number 46.
46. The request of Mr. E.K. Dr. Leonard Council for the petitioner matter stand adjourned for 2 weeks. Yes.
Where is the for listing of a I for implement. The tomorrow in the daily item number 25. This matter will take. I will take to be
Listed tomorrow.
tomorrow. WPC listed tomorrow.
All right, you bring it tomorrow. Give the number.
And
It will take tomorrow. Tomorrow is going to.
Please, your lordship, my lord, could be complaint of the other side, my lord. I'd like to mention item 11. I would like to file affidavit in reply. They have filed affidavit last occasion, my lord, so I would like to reply. Item 11. I filed one IA also.
This, you are for the
Respondent, my lord.
respondent. You are seeking vacating.
Vacating, but they have filed affidavit, so I would like to reply.
Is it not vacated already?
No, my lord.
Not vacated. 226(3).
Yes, my lord. Okay.
All right. At the request of MS K. David, matter stand adjourned for 2 weeks.
I let you.
Yes. Yes.
I'm able to measure definition something. The matter is not the agency is nothing. The matter related to the case is pending before the lordship can be given as tribunal lordship. And again, it will order lordship pass by the tribunal lordship. We approach their lordship. Lordship, the tribunal gives the matter on 31 lordship.
28. This on 28.
I have to mention item number 47, lordship. This must be adjourned for today, lordship. That must be not being well, lordship.
The request of Your name?
And that's Lordship.
N Das, matter stand adjourned for 2 weeks.
Much of.
Not this week. September, 11th September.
Day to mention item number 88 of supplementary list.
Yes,
This matter is very urgent matter, my lord, and I mentioned it, therefore this matter has been listed, my lord, but that too in order is by law, in supplementary list. So I have to regard to this urgency, my lord, may I claim for listing this matter, day after tomorrow. my lord.
why, what is wrong today?
Today in supplementary list, my lord. My lord,
Why are you apprehending that we will not complete the report? We complete it. You wait,
Okay, diplomat, and I'm sorry for making mention.
no problem. Yes,
Yeah, thank you, Your Lordship. I need to mention for withdrawal of data, Your Lordship. As per instruction of my Your Lordship, publication about 422 months. 2000.
listed today, not listed
It was not listed, supposed to be listed tomorrow, Your Lordship.
tomorrow.
Yes, supposed to be listed tomorrow. But we want to do a withdrawal of data.
All right, tomorrow.
Mention item number 54 and 25.
34 and 35.
Thirty-four, I am very qualified, 35 for the response.
34, 35 is the request of Learned Council for
Petitioner in item number 34.
34. Who's for the respondent?
Taking the consent of the.
Who's for the petitioner in item 35? They are connected matters. Have you spoken to them?
Yes, I am taking the consent of the.
The request of Mr.
AAM.
A. Ahmed, appearing to the petitioner in item 34. Matter stands adjourned for 2 weeks. It is further submitted consent of all councils, including council for the petitioner in item 35. Number 3 has also been obtained. Matter accordingly directed to be listed after 2 weeks.
Can it be listed on Monday?
2 weeks.
May I please Lordship? Lordship, item number 55, you know, supplementary list, it's for water stay getting. My lord, I for the repetition on it, I have filed today, my lord, during the course of the day, my lord, I will file my objection.
Let the matter, have you taken consent of the respondents?
I'm going to take it. I'm going to.
Yes. What do you say?
They want to file a.
All right, at the request of both parties, matter be stands adjourned for 2 weeks. 2 weeks. 30, 30. Yes.
So item number 17, my lord. We will adjourn for 2 weeks.
Item 17 stands adjourned for 2 weeks. As it is submitted by Mr. D.K. Borua, that the RBI Council, Mr. Day has suffered his submission. 2 weeks. 30.
In the concept of the I like to mention item number 15 and 16. London Council Sullivan.
15, 16 at the request of learned councils for both sides stands adjourned for 2 weeks.
Because
You are making a mention.
they have requested me, my lord, because he.
No, you have exceeded to the request, so it's an adjournment by consent.
Matter is ill.
No, we can't fix a date like this. On dates when matters were listed at the request of dates being fixed, and then you take an adjournment.
Actually, no problem on my part, their problem.
All right, 30th, 30.
One is non-appointment of the first election and another is.
No, we're beginning from 28th. Yes.
I think the manager for listing, my lord, for meta parties, areas salary, my lord. Pending since 20. Any demand.
28th.
Oh, that's good.
Daily list for withdrawal, item 1.
Heard, so as no councils. It is submitted on instructions that the petitioner does not wish to press the writ petition any further. Therefore, the petition stands dismissed on withdrawal. MS Satya appears for the elementary education. The petition stands dismissed as above. Infirmary query stands vacated.
For motion, item 2.
This leads to professional appointment. Certificate government. Okay, instructed to bring instruction whether my name is sent to the DLC after mediation of the
After instruction. This is the petitioner was rejected way back in 2011. The only thing that it was not communicated to the petitioner. Otherwise, it was rejected way back in 2011.
But there is no.
What is the ground for
And there is no ground.
resolution?
The ground is not.
Traffic kind of penalty assessed by DLC.
How do you know if you have not received a copy? You said there is no ground. Have you
No,
received a
that-
copy?
No, I have applied for the to RTI. After obtaining this, I have annexed so many
That
minute DLC.
DLC, is it available here in the
Yes,
page number?
page number 40. 21 proposals have been submitted for the first of your minor. My name is Devoti Dragon.
What instructions have you got? This minute.
That minus already the petitioner have. Whether that outcome of that DLC was communicated to the petitioner or not.
It was not
That's
communicated.
It was not communicated there. Then, but otherwise it was rejected way back in 2011.
So my humble submission, can we send the names to the DLC, that is that part, that is.
They have rejected your case.
But they have not communicated as per coordination practically, when the coordination case, it has been, it must be informed to the, communicated to the consent at this party, my lord.
Paragraph number.
Direction issued to record reasons when claims for rejected case of professional.
Paragraph 24.
Yes.
What have you received under RTI?
Actually, then they have supplied all the district level committee minutes to others. I have annexed some of the district level committee minutes, but it's annexed also. But my name is not there after 11 matter. Then I approve this on a good vote. And he is working, my lord, honorably in his father's place after death of the father, my lord. And headmaster also communicated several times to the inspector to the district level committee. I have annexed that too also. But no, nothing has been done by the district level committee. So my humble prayer-
You furnish the reasons, Mr. Government Council. Give us the reasons.
From the minus 16,
Minutes may not be there. It must be available in some file somewhere there. You give the reason.
my humble query is that my name may kindly be sent to the district level committee, nothing else. That is my prayer. Since after 11, they did not send a name to the district level committee. I want that direction, okay, nothing more than that.
First, you have to be furnished with the reasons. You get the reasons in the affidavit we see. You get the reason because after 2011, they issuing a direction to consider your name without getting to know what the reasons are. You must know the reasons.
But he should bring the reason.
He should.
Yes.
He's not done it. Why have you not done it? Bring it on an affidavit. Whatever reasons, or you can't bring it on an affidavit, get the relevant files. Mr. G. Pegu, Learned Counsel, appearing for the department, submits that he does not have the reasons for rejection of the petitioner's case under by the DLC. It is meeting held on 3003/2013. Which page you are referring to? Page number? Where is your case rejected?
Okay. 4014.
This is rejected by the DLC only.
Yes.
Minutes of the meeting held on 24/01/2011, whereby the name of the petitioner was not recommended for appointment before the SLC. So the counsel to the petitioner submits that as per the directions of this court in Qadirun Nisa, reported in so and so. The respondent authorities are duty bound to furnish the reasons for rejection of the candidature of any person applying for appointment under the compassionate scheme. So Mr. Behu is permitted 2 weeks' time to obtain the specific instructions as to the reasons for non-consideration of the case of the petitioner by the DLC for recommendation to the SLC. Matter will be listed after 2 weeks. MSK Devi appears for the petition.
That DLC date will be 24/1/2011.
Yes, stated that.
Item number 3.
Well, this matter was considered by my lord, this court on 2 occasions, and it was kind of slow. But no pleadings have been brought on record. It pertains to my lord, I was selected as the headmaster of a school, principal of a school. And my BEd degree was listed. How I have done this BEd degree was, my lord, the BEd college was adjacent to the school. And by taking a permission from the school as well as my lord, the inspector of schools, that my lord would find at page 26. Way back, my lord, in 2014. Then, my lord, I was selected.
26 is an application.
Is an application, my lord will see its application to pursue that course. Down below, my lord, on the left hand side. Allowed. He was allowed, and accordingly he took the admission. And thereafter, my lord completed the course.
Was that institution offering courses in the evening?
No, no,
Then
it was offering in the daytime. I, my lord, completed my classes and I went there.
after 3.
No, man, during that, I had 2 classes in the morning, I completed that, that was the arrangement made. After 12, my lord, I used to go there and I used to do my classes. And accordingly, there are no objection anytime. Now, the degree certificate is also there. The subsequent inspector, my lord, he writes that we don't have any records. But I bring that on record, that page 26, that is not disputed anywhere.
Yes, Mr. Chaudhary.
Lordship, initially the private respondent files the petition challenging the degree obtained by the petitioner as well as its principalship. And Lordship, during the course of the and earlier court also directed the director to pass a speaking order. And
That is at page 14.
and Lordship, during the course of the proceeding in the earlier writ petition, it came to light before the director that the inspector of schools report, wherein he stated that there was no record of the petitioner being allowed to attend the classes of BA. Lordship, that was never put before the director for while passing the speaking order. That's why, Lordship, the court interfered with that speaking order, and the director again passed an order wherein it came to light that he cannot continue with his study in BEd, and classes in the school at the same time. And subsequently,
That is a sequel to the first, whether you have given a permission or not.
That nowhere denied.
Lordship, that was subsequently got, Lordship, yet, but we will have to give out reply, Lordship.
No, my lord, in page 33, the inspector's report that is taken note of. That is of 2020. The permission is of 2014. Page 33, my lord, will have.
33.
Yes, your lordship. The application is of 15/7/2014, first paragraph, first serial number 1. In this connection with the application dated so and so for permission to study higher education, it may be stated that no record is available of receiving such application in this office as now copy enclosed in annex of 1. However, no forwarding letter of school author of such application regarding permission of BA study was received by this office. But the office of the inspector of schools himself and my lord, permission.
Who's for the principal? Who's appearing for the principal? Anyone for the principal?
In this repeat proceeding, no, Lordship, earlier.
Now, my lord, I was given the appointment on regular basis, thereafter the challenge. Now, my lord, at page 49, the speaking order. By this, my lord will have relevant 50. That appointment on regular basis has been cancelled. And the private respondent has been allowed to hold the charge on, my lord, in charge basis. The ground is same as has been written by the inspector of schools, but the fact that document is there, the signature is there, nobody has seen, I think.
Where is that original? Where is that original?
Yeah, original is a page.
It will obviously not be with you. Not supposed to be with
No,
you.
no, it will be either in the school or I am the holding the charge now. It will be in the school.
All right, has notice been issued in the matter?
This was given to the B.Ed college also.
Has notice been issued?
No, madam, notice has not been.
Heard learned counsel for the
Madam,
parties.
one factor, if I might just point out.
Yes.
This order was issued on 27 July 2023. Thereafter, my lord, I immediately approached this honorable court. And my lord, there is a status quo order already. But now, on the day, they had shown that she had gone and joined before the inspectors. And the thing is, they have also admitted that the charge has not been handed over by me. Now what they are trying to do, my lord, even police cases are being tried to be filed against me for handing over the charge.
You are the principal of
I was not principal on the regular basis.
which college?
My lord, it is my lord Boroma HS school, man. My thing was interfered, that cancelled on 27/7, and she was allowed to take charge. Now, my lord, there is a status quo order.
The
I have not-
principal of your college, sorry, who looks after the governing council is there, governing body.
Governing, managing. But I am the principal still.
And who was the principal at the relevant point in time?
That was my lord. No, yes, okay. 14, Vidyasagar Ramsiari. At page 26 is name. And he is the person, my lord, who has been giving me all those permissions.
Now, who's holding charge here?
I am holding charge.
You're
I have
holding.
not handed over charge. Although she claimed that she had gone and joined before the office of the inspector of schools. That will not work because it's a principal person.
Page 49, this speaking order was passed in terms of the honorable court's order. Honorable court's
No,
order.
that we understand who's in charge now.
Yes, madam.
My lord will have that, my lord, page 59. If my-
There is a status quo order.
Before that, I have taken.
No, he has not taken.
Before that,
My lord will have running page 59. The additional evidence.
on 29. July, I have joined before the inspector. And he obtained the status order on 31st of July.
Whoever is,
My lord will just have that page 59, my lord, that will clarify the issue. Page 59, additional evidence. Yes. Running page 59.
yes,
My lord will say this is from the inspector of schools. The inspector is taking a very dubious role here now. As per letter received from so and so, It has come to my notice that as per order of so and so, you are directed to hand over charge of so and so. But it is found that you have been not followed the direction of the competent authority till date, which is a serial offence under so and so. In this case, while disciplinary action should not be asked, so and so, otherwise any departmental action will be initiated against you without prior information. Now, my lord, this is on 1/8, on 31/7, this honorable court had passed a status quo. So, my lord, I had not handed over charge. I am holding the charge.
On 31st of July, you have to reflection, I have already joined the Kodak Inspector of School.
My lord, we have that page 62, that joining report of the petitioner. She comes to the school, she writes to the president on 7/8/23. My lord will see what she has written, page 62. I have
All right,
already informed you
You
that
file your,
I.
Mr. Chaudhary,
Yes, my lord.
please get your instructions and file them.
Also, this additional affidavit has not been served upon.
Have you initiated proceedings on the petitioner? Your department's case is that his BA degree is not as per procedure. So you have to take steps under the provisions of the Act to initiate proceedings if you think that this is not correct.
That's
He is a
what.
regularly selected person.
Yes, yes, my lord, that also our stand was in the earlier proceeding that we cannot declare the degree to be invalid, but if he has done wrong, lots of action will be taken.
And that's one under the 64 rules.
No. Action taken on what basis? If the inspector at the relevant point in time has granted him permission, then he has only pursued the matter with due permission. Your office says that there is no record.
If the permission is given, then the copy of the record of the permission given is ought to have been there, but it is not there, and so there is some
Who has given that report? Who has given that finding?
subsequent, the present incumbent, lordship. Inspector of school, lordship.
Where is that report?
On page 33.
33. That I have just taken my law group,
Yes,
that's serial number 1.
there is no record. Record where? In the office of the inspector.
Inspector.
Regarding submission.
And
of
this
that-
was given in 2014. And this subsequent communication is of 2021. 7 years of.
That page 33 was passed in terms of earlier round of litigation.
No, this is my lord.
In connection.
He has given a report when she filed a case.
In
To make
connection.
a case in her favor. Till that time, there was no dispute.
Very well, you get your instructions.
Yes,
I don't have to.
And my regular promotion order is at page 37, which has been now interfered in this now.
All right, heard learned counsels for the parties, Mr. V. Chaudhary, learned standing counsel education. Praise for it is granted.
Lordship for BTC 3 and 4.
You are for
For BTC.
BTC,
3 and
appearing for BTCs. BTC 3, 4. Who will appear for 1, 2? Appearing for BTC, who will file the affidavit? BTC.
BTC, lordship 3, 4 and 5.
File the affidavit 3, 4 and 5 within 2 weeks from today. Mr. Chisti appears for respondent 1, only 1.
I'm going to number 6.
Mr.
Yeah.
K.
Yeah.
A. Ahmed appears for respondent number 6. And anyone for the other?
Lord, others, my lord, will have to-
NCTE, I think, has a standing counsel.
One and same party topic, one movie to particular number of students and one. I don't know the same party.
My lord, 10, my friend will. do. Others I'll take steps.
Then Mr. Sormaikis and so. Steps on respondent 7, 8, 9 by registered post daily within 1 week from the. Matter be listed after 2 weeks on 28th. 31st. Until the next day, status quo order will continue.
Item number 5.
Before my last serious and start question, here they are made grievances against an order issued by the Commissioner Secretary Finance Department. So Finance Department is not a party in this, though they are party, their name is also in the causes of it. Because they have certain question of an order issued by the Commissioner Secretary Finance.
It was at least hearing first. Yes, the matter has come up for the first time.
Yes.
Yes, yes.
My lord, in the year 2002, my father, that Krishna Kanta Das was killed by suspected alpha. At that time, my lord, there was a policy of the government to provide a job as well as some amount of compensation. But that was not paid, a large number of communications were made.
Who is supposed to have paid you that amount?
It will be paid from the finance department as well as the.
Secondary Education Department has already provided, has been informed to provide ex gratia of 3 lakhs.
That is also not paid till today.
So who is the Secretary Education? Page number 67.
Yes.
It is the Finance Department who says
Yes.
that you have been informed to pay. So get your instructions why you have not released that amount of 3 lakhs, or has it been released in the meantime?
But he is based on staying of this particular order, no.
He wants an appointment,
No.
but his claim is alternative prayer is that this 3 lakhs, which you are supposed to pay, that also has not been paid. Heard Mr. M. Mahmood, Learned Counsel for the petitioner, Mr. T. Chisti for the respondent Education Department. Respondent 1 and 3. Who's for the personnel? Mr. G. Pegu for respondent 2 and 5. Mr. B. Gogoi for respondent number 4, finance. Let the respondents, finance department and the education department produce before the court the status of the grant of ex gratia for rupees 3 lakhs. As was required to be paid in terms of order dated 11/5/2023. So instructions be placed before the court on 28th.
The beginning appointment will be considered.
Let us first have that instruction.
Only what we have published the finance.
Mr. Counsel for the petitioner will furnish extra copies to the respondent counsels. Names of all the respondent counsels will be reflected in the posts.
Item 6.
Sorry for the intervention, Lordship. But I make a mention in the morning, item number 34. There is an interim Lordship.
This is not the way to make a mention. You wait for your turn. You wait for your turn. We are in the middle of a proceeding. You can't just barge in and make a mention.
So see, in this case, my lord, petitioner number was appointed as a assistant teacher in 2006, and the private respondent number 6 was appointed in 2010. Accordingly, the district school in the committee recommended the name of petitioner and private respondent number 6 for provincialization of their service. Page 43.
Yes. 40.
43, relevant question page size 45. Column number 6, madam. The details of people eligible for provincialization. 3, madam, Masuma Ahmed. Column number 6, page 45. Masuma Ahmed, serial number 3, that is the present petitioner. Here the recommended 80 as language teacher for provincialization of her service by the district committee. But the by the website list was 47.
They have provincialized the two teachers. Munna Ali, he is the science teacher.
Okay, we'll issue notice at this
So,
stage.
my lord, in this case, my lord, same ground, again and again, that particular director is in the.
We'll have to issue notice.
Kindly permission for the moment, my lord. This is the violation of the court order.
Which one?
My lord, case 61. Page 61, relevant portion, my lord, page 64.
Where is the direction of the court?
My lord, page 64.
64.
Paragraph 6. Accordingly, we interfere with the order dated 7/1/2022 and direct the director of elementary education Assam to determine it who would be entitled to the provincial. Now, my lord, kindly see the order that is, my lord, page which has been interfered with, that is page 59. 59.
No, what is the, which order are you putting to challenge now?
Now, my lord, the recent order is page 66, same order, my lord. Earlier had been interfered, again same order has been passed.
Let her, let the council to the parties issue notice, returnable 4 weeks. Mr. Kaushik appears for
1, 2, 4, 5,
1, 2, 4, 5,
or 1 to 4 and 5.
1, 2, 4 and 5.
I appear for respondent number 3.
Mr. Pegu for respondent number 3. Steps on private respondent within 1 week from today. Since none studying councils have entered appearance. Notices are waived, however, extra copies be furnished within 1 week from today. The provincialization of respondent number 6 will be subject to the outcome of the.
He is also not eligible. The order says because harmony.
Subject to the outcome. Prayer for interim will be considered upon service, upon return of service.
Item number 7.
Yes,
We have challenged the word Nippon order, that is what you will find, but at page not 70.
70,
72.
72. Yes,
Now, Muller petitioner has declared on Muller 39/2022
as
as head teacher.
teacher.
Now, page 72, Lordship will find the Muller non-liability certificate issued at the time of retirement has been Muller cancelled. Page 72. That to Muller without any notice, Muller any report. Page 72.
Has the amount been sought to be
Yes.
recovered?
Now, Lordship, can you see the another Nippon order at page 74? Page 74, my lord. They, my lord, directed the petitioner, the respondent authorities, my lord, to recover an amount of this 3,84,272. Page 74.
Okay, heard, London Council petitioner. And
I put 1 and 7.
Mr. Pegu for 1 and 7, MS Satya for
2, 3, 4, 5.
2, 3, 2, 3, 4,
5, 6, and 7.
5 also.
5.
Mr. Pegu for 1 and 5,
1, 5 and 7.
1, 5 and 7. MS Satya for 2, 3, 4 and 6. And 8. Notice of the private respondent by registered proceeding within 1 week from today. Since learned councils have entered appearances, no notices be served. And notices are waived, however, extra copies be furnished, issue notice, return it in 4 weeks. Till the next returnable date, the order dated 6/6/2023 shall remain strict. Placed on 1st of September.
This is 16, I think.
Is it 16 or 6? 16.
My lord, 1600 means because, they didn't return the unplus, my lord, which is full of 97.
No, there is a. You have returned it amount?
No, I am ready to return the amount, unutilized amount, that is 2,19,000,
Okay,
not this amount you put.
the amount directed to be recovered is 3,84,000.
Yes,
Then,
then my lord, the unutilized amount is my lord only my lord.
so that will require some consideration whether it is 3,84,000 or 2,90,000.
Yes, yes.
Who will decide that? So we are issuing notice. This order is late till the next returnable date. However, tendency of the writ petition will not be a bar to give to pass appropriate orders in respect of the petitioner if will not be a bar to for the petitioner to return the unutilized amount. You return it.
Yes.
You return.
Did notice.
Let him wait.
Yes.
May I please introduce? Lord, in this matter, we have challenged an order of amalgamation as not as per the recent policy of the government. My lord may be pleased to find the initial impugn order is at page 44. My lord, in this order, my lord is found in the heading of this order, my lord, in pursuance of so and so of the Act of 2017. The Assam Education Provincialization of so and so Act of 2018. The Governor of Assam is pleased to provincialize the services of the teachers, of the tutors, and the non-teaching staff of the Akka High School, District Kolkata, with effect from 1st January 2021 with the following terms and conditions. Number one, the Kayakusi Higher Secondary School is identified as the base school for this school. The concerned teacher of the tutor will have to join in the base school and he has to perform duties in the base school. This order, my lord, has found that was issued on 4th of January 2021. Although my lord, this has been identified, but the present school has been allowed. My lord, the staff had also been allowed from functioning in the my lord petitioner's institution, that is Akka High School. My lord, what has happened when we have come to know regarding my lord this arrangement? Immediately, my lord, the local public guidelines as well as the my lord teachers as well as the other stakeholders has made a specific representation before the director of the secondary education of Assam. My lord, may be pleased to find that representation starts with at page 54. Another the last representation, is that page.
So what is the effect of this order at 44?
The effect of the order is at page 44 is that.
Kayakuchi is identified as a base.
Base school, we have to sort out. Under the log and key of the school, as a result, the staff as well as the infrastructure, all will have to be shifted to the base school, and both the school will get merged, as per the policy. Now, for that reason, there is a provision prescribed under the statute of the 2017, section 3, subsection 6, clause A. My lord, may be pleased to find in this book, at page 113.
Yes.
This is the provision starts at section 3, subsection 6, clause A. The government, page 113.
Yes.
The government of Assam shall identify the base school for the purpose of provincialization of the services of teachers of the venture educational institution, so as to fulfill the norms and standards required for the providing the educational institution within a specified area as follows. My lord, can skip the first few words because these are not relevant with us, but the clause 3 is relevant. At least one high school or high madrasa within a radius of 5 kilometers and at least one higher secondary school or the junior college within a radius of 7 kilometers. Now, my lord, our school, my lord, has already found that actually, my lord, directed to get marked with the Kayakuchi Higher Secondary School, my lord, which is more than within a radius of 7 kilometers. That's for my lord, the geographical area, if it is calculated in its practical, or the proper perspective. So, my lord, this is in violation of the clause 6A, 3 and 4. Secondly, my lord, it has also said that if any provincialized school already exists within the aforesaid is radius, the existing provincialized school shall be identified as the base school at the exclusion of a venture educational institution with the same radius. Then we have provided that in case of 2 or more existing provincialized educational institutions within the radius of the area as specified in clause A, the district scrutiny committee shall identify only one of the such educational institution as the base school, considering the existing infrastructure and other amenities and facilities available in the such educational.
So how has it been violated? According to-
Our school, my lord, can also be recognized as a base school, my lord, because we have the infrastructure and the district scrutiny committee, my lord. My lord, when they have considered, they have not considered these aspects of the matters, my lord. So, my lord, therefore, this is first of all is in violation of this.
How is the process to identify, is it prescribed under the rules? How to identify
My lord,
the base school?
my lord, that process has not been, my lord.
Is there a set of guidelines? Is there a set of guidelines or?
No, my lord, there is, it is the discretion of the, that's why, my lord, the arbitrariness and illegality has come up. My lord, what has happened? When this type of, my lord, arrangement has been made, lots of complaint and my lord, maybe please to find in the impugn order, my lord.
All right, now this order has been passed
My lord, it is
in
of
2021.
25/8, my lord.
It is passed in 2021.
My lord, no, my lord, the last order of amalgamation, my lord, has been passed on 25th of August 2022, by which we are affected, my lord.
Page
Is
number.
at page 46, my lord, may be pleased to find. Our serial number is at 13, my lord, of an order dated 25/8/2022, my lord. This has been made, if my lord may be pleased to find at serial number 13 is the of Orchestra district, my lord.
Yes.
My lord. Now, my lord, our school is again directed to be marked with this high school, which Kayakuchi Higher Secondary School. My lord, what has happened? It is not the petitioner school has been singly directed to be amalgamated. Lots of schools were incorporated in this impugn notification. My lord, thereafter, my lord, certain allegations and complaints were lodged before the government. Government constituted a committee, my lord, and thereafter, my lord, some of the schools amalgamation order had also been cancelled. My lord, a series of writ petitions have been moved before this honorable court, my lord, challenging the said order, and this honorable court was pleased to suspend the impugn order. One of such similar order, my lord, I have annexed, my lord, may be pleased to verify from page number 63, my lord. The impugn order had been suspended, my lord. I have to fairly submit that, my lord, this is the, although this order has been issued on 25/8/2022, my lord, but till date, the school has been allowed to function from its present location, and the last impugn communication has been made at page 60, my lord, at dated 7/7/2023, my lord. That's why now we are before my lordship, my lord. As we have been pressurized, my lord, our grievances have not been mitigated, my lord.
Yes, Mr. Kaushik.
But when these schools are taken up for consideration for provincialization, as per section 13(6), these district scrutiny committee identifies the base school and prepare the list of eligible teachers. This is a process which is done prior to provincialization, and they have been provincialized on the
So
basis
what
of
is the status of this writ petition? 5979.
My lord, this has been moved by me, my lord. This has become infructuous because of that schools, my lord.
Then why are you referring to this interim
My
order?
lord, the interim order was issued, my lord, in that respect. Pursuant to this petition, my lord, final order, my learned friend was not there, my lord. Suddenly it has been annexed, my lord. After the annexing, I could learn. My lord, what has happened, my lord, this order dated 25/8/2022 had already been revoked by the government, my lord, in respect of that school.
All right. Heard current counsels for the parties. They agree by the order taken. Where is that order?
My lord, is that page, page 45, page 2022, page 46.
4th of January,
25, 8, 2022,
page number
page number 46.
6.
And the last communication from, is on page 7/7/2023, page 16. Inspector of school again asking us,
No, but you are not putting to challenge 4th of January.
no, where,
4th of January is not challenged.
but the original order of provincialization, they has not been challenged.
Yes.
Because it has been the, provincialization has been made. After even-
Have you put to challenge the order dated 4th of January 2021? You're not.
It is the order of provincialization,
No, this is the
original, basic school identification.
base identification.
The same school is identified again by 25th of August. Now, may I clarify one thing here? When these provincialization orders were passed, there were some complaints and the government constituted a committee to revisit the identification of the base school. So in respect of the petitioner school, it was revisited and it is found that this base school is the proper school which can be marked with.
Where that order is probably not here.
That order, that revisit decision has not been furnished to us.
There was a general circular, Malad, if you lordship find page 44, they were supposed to immediately join the base school. But there was an order from the government saying that
In
the
so far as Kayakuchi 44 is the first order.
first one.
So that has not been recalled. That is what I am asking you. Is it under challenge? It is not under challenge.
No, Milord, because if we challenge it, Milord, then our provincialization is going to be strike out, Milord. That is another problem.
Your grievance is that
Regarding the.
this school, there are other schools or your school which ought to have been identified as a base school. Instead, this Kayakuchi has been identified. Now, this is done pursuant to an exercise taken by the government. You are not putting this to challenge.
No, Milord, this is followed by the latest implementation.
Exactly. So this is the identification.
Because, Milord, both the orders have been get merged, Milord, from my
How-
understanding.
How can it get merged?
Because, Milord, this 25/8 is the again reiteration of the earlier one, Milord. This is
No,
the latest one.
this 25/8 refers to an order of February. So after 4th of January, there is another order pursuant to which 25/8 has been passed.
Correct, Milord, correct.
Anyway, it is your call. You decide. Third learned counsels for the parties. This petition is filed by the petition to question the order dated 25/08/2022 issued by the Director Secondary Education whereby under the Kolkata district several schools have been merged with a base school which is identified as Kayakuchi. What is the name of the base school? Kayakuchi High Secondary.
Higher secondary.
High Secondary School.
Serial number 1.
By order dated 25/08/2022, Director of Secondary Education has issued the order by which several schools within the district of Borpeta has been identified and merged with the schools, merged with the base school reflected in the same order. In so far as the petitioner's school is concerned, the name of the school is shown in serial number 13, and it is directed to be merged with the base school, which is Kayakuchi Higher Secondary School. The council put a petition and submits that this order is contrary to the provisions of the section
Section 3, subsection 6.
Section 3, subsection 6 of the
The Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017.
this is 113.
130.
of the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2017. Stop. Learned Council for the petitioner submits that. Pursuant to the order being passed, the designated committee, what is that committee called? The committee constituted by the government.
As per the statute, the district scrutiny committee prior provincialization you have to identify. But subsequently, there was a committee set up.
Committee constituted and set up by the government
The district
Had
level scrutiny committee for selection
also
of a
revisited the issue of merger. But
Identification of the district.
identification of the base school and the petitioner school has been identified as a school to be merged with the base school identified, which is Kayakuchi High Secondary School. So Learned Council for the petitioner submits that this findings of the committee constituted has never been served on this school. Where Mr. B. Portion Learned Council, Standing Council Education, Elementary. Education, Secondary education. Appears for respondents number 1, 2, 3, and 5.
1, 2, and 3.
1, 2, and 3. Mr. Sharma appears for respondent number 5. No. Mr. Pegu appears for respondent 5. Since Learned Standing Councils have already entered appearances on behalf of the respondents above named, notices of waive, not by extra copies be furnished with that period of 1 week from today. Steps of respondent number 6 by registered post within 1 week of list after the return of the leaves.
No, they don't order and I will stay. Otherwise,
This is an order of 25th of August.
The prayer for interim will be considered upon the return of the leaves.
who have been pressurized, because if you are required to go and join their petition will become. Till the returnable date,
Not present. Because this is
This
not similar, demands that they.
give us a reason for granting you a stay.
No, because still they do the functioning in our.
That is not the ground the act permits merger.
No, X permits murder, but.
You tell us that the provisions have not been followed.
Provision has not been followed, Milord, and moreover, Milord, when we raise the demands before the district committee, Milord, the committee has also not, Milord, addressed our demands, no hearing has been afforded to us also.
they accepted the provincialization melody on the basis of that recognition of the district scrutiny under.
The respondents will not insist on the merger till the next return. Based on 28. No, 31st. Sorry, 1st September.
Item 9.
What is happened is in the meantime, 2022, the principal had retired. The reference is nearly forwarded. So it also currently comes to page 26. While we sorted the inspector of schools was allowed to temporarily was the charge of the principal of the school. There has to be paper representation. After the representation, the include taking order was that is at page 29. Page 29 is taking order. The element is at page 29A.
Page
29A. May. During the course of hearing, Ami Shamsul, the district petitioner, was asked to submit the caste certificates of MA and BA along with documents relating to the permission he obtained from the competent authority before pursuing MA and BA degree while he was in service.
It is found that he completed his MA course in the year 2004 from so-and-so University, Kanpur, with NOC obtained from Inspector of Schools, Kamrup, and obtained leave on private ground from Inspector of Schools, Kamrup, during the examination period. So far as period is concerned, okay, he passed from University of Meghalaya in the year 2015, for which NOC was granted by the then Inspector of Schools, Kamrup, and R&D was granted during the examination period on private ground by the Inspector of Schools. So, Lordship, for undergoing both the courses, due permission was accorded by the respondent authority. And accordingly, I had done I had undertaken the courses. Now, Lordship, there are next paragraph. The authorities say, as per government notification dated so and so, 30th September 2021, any degree obtained by from the University of the State is valid within the territorial jurisdiction of the state. As there is no study center in Assam for pursuing B.Ed course under University of Meghalaya, and B.Ed degree obtained from University of Meghalaya in respect of the petitioner cannot be accepted. And accordingly, Lordship, we are not allowed to make a charge of principle. Now, Lordship, this notification, you can Lordship kindly come to the B.Ed certificate, Lordship, that is at page 30.
You are working in which school?
Lordship, Sontali Higher Secondary School.
Where is it situated?
Lordship, it is in Kamrup, Lordship.
Kamrup, where?
Rural, Lordship.
Which part? Anyway, then you pursued your B.Ed in Khanapara during the school hours.
Lordship, there is a certificate to the by the university, there is a page 33.
33.
Lordship, wherein the university has stated that they had special classes on Saturdays and other ones. Page 33. Lordship. Yeah. This is to certify that Mr. Aminul Samsul Anwazki petitioner was a bona fide student of our university bearing roll number 12. They had successfully completed the B.Ed course in July 2015. This is also hereby informed that Mr. Alam had attended special classes on Saturdays and other holidays as a service student, and his aggregate percentage of attendance is quite very much good. Now, let's take the whole contention of the respondents is that after commencement of the 2021 notification, degrees obtained from universities which does not have a study center in Assam will not be considered. Now, in that respect, when the B.Ed degree was obtained by VB of 2015, the rules of 2003 amended in 2012 was in force. If you don't want to kindly take up those rules.
See, there are other issues also, because it falls in a different state. So you have to, do you not have to take permission to leave the state?
Lordship, we have taken permission. Lordship, there.
Where is that
The speaking order, Lordship, the authority that taken them. Page 29A. The authority stated that I have taken permission from the inspector of schools and had also taken leave during the examination period. This is the observation by the authorities themselves.
Yes, respondent who's appeared.
Taking NOC is not the issue here. His B.Ed degree has been invalidated on the ground because one of the office memorandum that is page 31. The notification.
P1.
Yeah.
Yes.
Lordship will find page 32, clause 4. Degrees obtained from the off-campus distance education having recognized study center in the state of Assam which are duly recognized by the Distance Education Council under the University Grant Commission shall be considered valid for the purpose of employment under the Secondary Education Department. However, in respect of those institutions located outside the state of Assam but having a study center in the state which is not recognized by the Distance Council under the University Grants Commission, the degree certificate issued by such institution shall not be considered for valid for the purpose of employment under the Education Department.
He does not fall under distance. He has gone there and attended the classes.
My lord. But the
Distance is where he doesn't go.
my lord.
He doesn't go. He obtains without attending the.
However, this certificate of faith issued by the US game will be valid. Because the NCT,
Who will examine that?
NCT is not a party.
No, you have already arrived at a finding that this is incorrect.
Sorry.
At page number 29.
Because as per the NCT regulation, madam, there has to be regular classes of the BA.
So you show that certificate.
The certificate they have annexed, that they have been allowed to attend classes of
He has attended regular classes
regular.
by going there. It is not a distance education. Only difference is that the certificate says he has attended it
On holidays
on
and
holidays
and
and
Sundays.
some special Saturdays.
Madam.
So you'll have to examine this matter. Anyone for the NCT? You have not served copies on NCT. There is no study.
NCT has not been available.
Taking order.
NCT you will have to be made a party.
Yes.
Third learned counsel for the party case. That petition is filed by the petitioner to challenge the order. Dated 15/7/2023, whereby the Director Secretary Education has arrived at the finding that since there is no study center in Assam for pursuing B.Ed course under USTM Meghalaya, therefore the B.Ed degree obtained by the petitioner from the USTM Meghalaya cannot be accepted. So, learned counsel for the petitioner submits that he is presently holding charge as the headmaster.
No, I have not been given the.
You are not given the charge.
Inspector is
That order of the That is the page 20.
Yes, the petitioner is the senior most.
Actually, I am the second thing I am the senior most is also given an enough that he is willing to take up the charge.
He is the second senior most teacher in
Suntali Higher Secondary School.
in
Suntali Higher Secondary School.
Suntali Higher Secondary School. Stop. It is the submission of the learned counsel for the petitioner. Where is the NOC?
The senior most,
Yes,
that is at page 28.
is submitted by the learned counsel for the petitioner that the senior most teacher, namely one Ahmedullah Chaudhary, has already issued an NOC. Submitting that he does not wish to take over the charge of principal of the same school because of personal reasons. So, said NOC is enclosed as an Annexure A4 to the writ petition. Stop. Learned counsel to the petitioner submits that the petitioner attended the B.Ed course from the same university upon obtaining necessary permission from the inspector as well as the headmaster. Where is that permission? NOC from inspector.
But the finding of the authority, we have based upon the taking order. The authority found that it.
So, learned counsel for the petitioner submits that this is not in dispute as the same is reflected in the impugned order itself. So, it is submitted that the course obtained by the petitioner was attended by the petitioner physically in the USTM University. So, it was not a distance, it was not through distance education mode. And therefore, the circular of the UGC relating to courses being availed of in the distance education mode is not applicable. So, in that view of the matter, the petitioner relative has approached this court, praying for appropriate orders. Param District Court, Learned Counsel Standing Council Education agrees for
All the respondents,
all the respondents.
one to
He
the
submits that NCTE is a necessary party as there is a mandate under NCTE that B.Ed courses should be
coordinate regular.
only in the regular mode. Stop. And in that view of the matter, notice we issued returnable 4 weeks. Steps. Since Learned Council for the respondent was entered appearance, notice was waived. Extra copies be furnished. The oral prayer of the petitioner is accepted for hearing the NCTE as a respondent number 4, which is considered to be a necessary party in view of the fact that the question of the validity of the B.Ed degree of the petitioner has been raised. Stop. Petitioner will file amended post title in the registry showing NCTE as a respondent number 4. Till the next returnable date, in due order, dated 15/7. Shall remain stable. Please come first.
Item number 10.
None appears. Pass over. You are appearing for respondent. Well, petitioner is not here. Pass over.
Item 51.
Pass over.
52.
Please, Your Lordship. The petitioner initially was potentialized manner, but subsequently by impugn order, dated manner page manner
Heavy, does it?
92,
Heavy.
page 92.
Who's for the caveat? Who's for the caveat? Who's Mr. Abu Sayyed? Yes.
My lord, impugn order page 92 manner. The potential order of the petitioner was cancelled by considering his wrong date of appointment. My lord, kindly page 93. Date of appointment of the petitioner was considered as 2002, whereas he was appointed in 1993 manner. And the respondent number 9 and 10 was junior, but they are my lord, service was considered for provincial additional matter. Right, this my lord, kindly see page my lord, page my lord 35. Is the my lord resolution
30?
35, 35.
No, you are referring to page number 92.
My lord,
Yes. What is the finding?
page 92 is the impugn order.
Hmm.
Then we will come
What
to
is the,
page
what is
93.
the finding?
My lord, my lord, come to 93 man.
97.
97 my lord, page 97. My lord, is the order. My lord.
Yes, easily.
The whereas someone service of the petitioner was cancelled, potential was cancelled. As by considering that he is junior to the my lord respondent number 9. And then my lord respondent number 10, he was considered as my lord only teacher against the my lord social science. Whereas my lord he was
What is the subject you teach?
my lord petitioner was headmaster my lord. So headmaster teach my lord all subject my lord. My lord kindly see my lord page 90, page number 35 my lord from start my lord. The fact will clear my lord.
Yes.
My lord, this is the initial resolution. By this resolution, resolution number 1,
Hmm.
the my lord, respondent number 9 was appointed as headmaster. Sapir
Hmm.
was appointed as headmaster. And resolution number 2, petitioner was appointed as my lord assistant teacher.
Abdullah Khair. Then my lord would come to page my lord, page my lord 37.
Hmm.
The appointment of the petitioner my lord, as assistant officer my lord.
Yes,
Then my lord would come to page 39 my lord.
Hmm.
Petitioner joined my lord,
yes,
joined my lord in 1993 as assistant officer. Then your lordship would come to page my lord 41.
41,
41.
yes,
My lord Safiul Islam, the respondent number 9 my lord, was appointed as headmaster and he joined my lord in 1993 my lord. Then your lordship would come to page my lord, page my lord 43. 43 my lord. It's my type to be vernacular is 44, it's a clear page my lord, 44. The respondent number resigned from his post service my lord. And his resignation was accepted my lord, kindly see page 45.
Hmm.
By this resolution, my lord, can you see the headmaster post was resolution number 1. Nurul Amin Ahmed my lord. 6 my lord, line number 6 my lord. Resolution number 1.
yes,
Nurul Amin Ahmed was appointed as my lord headmaster in his place my lord.
Hmm.
So my lord, respondent number 9 was out of service my lord. Then your lordship would come to page 47 my lord.
Hmm.
Nurul Amin Ahmed was joined my lord, appointed as joined in 1997 my lord, in that as headmaster my lord.
yes,
Then your lordship would come to page, my lord, page 48.
Hmm.
This is the appointment of the respondent number 10 my lord. Respondent number 10 appointed in 1998 as my lord, second additional assistant officer my lord. Then your lordship would come to page my lord, page 50 my lord. The subsequent headmaster Nurul Amin Ahmed was resigned in
50,
50 my lord.
50.
The subsequently appointed headmaster Nurul Amin Ahmed was resigned. And in his place my lord, petitioner was appointed as headmaster my lord. That is my lord, he was promoted my lord. Kindly see page 50 my lord. Abdullah Khair, temporary appointed as headmaster my lord. In my lord, on my lord 11/3/2022 my lord.
Yes,
Then your lordship would come to page 52.
yes,
52 is the resolution where the my lord petitioner was appointed, my lord upgraded as headmaster, resolution number 1.
Hmm.
My lord, it is dated my lord 9/3/2022. There are 2 my lord.
Hmm.
My lord, can you see resolution number 2, page 53.
Hmm.
By this resolution, same resolution, by this resolution, my lord, Safiul Islam was appointed as assistant officer again my lord. In the period where the petitioner was served my lord. Petitioner was upgraded as headmaster and in his place my lord, Safiul Islam, the respondent number 9 was again appointed as assistant officer my lord. So my lord, the respondent number 9 subject start from my lord, 2002 again my lord. Is a my lord fresh appointment.
Now why your name has not been recommended?
My name was recommended when I was student select my lord.
Then,
My lord, subsequently by an application of the respondent number 10 my lord, which was the filed with petition my lord, this petition referred to the my lord, department
Authorities.
to consider the case my lord, and in that case my lord, the respondent number 9 and 10 my lord was student select
by which order? 26,
my lord,
page number 92.
92 my lord.
Yeah.
My lord, kindly see the my lord date, my date of appointment was considered my lord, page 93, table my lord.
Yes.
Is the table my lord, first name Abdullah Khair, my service my lord, date of joining in the my lord, last second column my lord.
Hmm.
My lord 33/12/2002 my lord.
Your name is at serial number?
Serial number first my lord.
Ah,
Abdullah Khair Ali.
yes.
Abdullah Khair Ali, date of joining mentioned here my lord, 3/12/2000.
Number 2,
Number 2 is the my lord, the respondent number 9. His appointment was considered mentioned here my lord 1/4/1993. Whereas
hmm,
he was resigned, then he was my lord again entered in 2002 my lord. So my lord, instead of 1990, it ought to have been my lord 2002. Then my lord, next my lord, 4 my lord serial number Abul Hassan.
hmm,
Abul Hassan my lord mentioned as 1993. Whereas he initially joined in 1997, 1998 matters.
No, your joining was in,
My initial joining my lord 1993, then promoted as my lord headmaster in 2002 my lord. So my service my lord should be considered with effect from 1993, but here my lord they are considered from 2002. Then your lordship could come to page my lord, page my lord 72 my lord. Sorry, my lord page 69 my lord, first, annexure 6.
what was the final order passed here in 90?
Final order passed my lord, respondent number 10 and petitioner number I. Both considered as my lord language teacher. So they find that my lord only one language teacher can be provincial, out of which the senior. As per their my lord view, my lord, I am junior to the my lord respondent number 9. So my lord respondent number 5 service was considered as provincial.
We'll issue notice here.
No, well, before that, I am for respondent and caveat. My respect.
You were not there when we called up, heart, learned so and so, caveat discharge.
I'm sorry.
Yes.
Madam, in fact, what is
What did you do? Caveat.
Madam, my arrangement has been done unnecessarily because your lordship will kindly see it is a fray between the petitioner and the respondent 9. They both belong to language stream, madam. And I am from madam social science stream, and this has been my lord settled by the honorable court on the earlier proceeding. And under the scheme, my lord, one candidate from each stream, my lord, from social science.
He claims his appointment from 93.
My lord, whatever may be, he, my lord, his fight is, my lord, with the respondent 9. And this has been settled by this honorable court on the earlier proceedings, my lord. Saying that I am from, my lord, social science studies, my lord, stream. So therefore, he cannot have a claim in respect of my post, my lord. And by the impugn order, my lord, my service has been provincialized, my lord. So therefore, essentially, my lord, this is a fight between the petitioner and respondent 9. Both of them belong to my lord language stream. If your lordship comes to page my lord 81, my lord, the honorable court has made it absolutely clear. It starts from page 78. The relevant my lord part is at my lord paragraph 5. Page 81. Man.
Yes.
I'm reading paragraph 5. On the perusal of the documents filed with the petition, prima facie it appears that Mohammed Abdul Akir Ali, this is the petitioner, my lord. Respondent 4 is a language teacher appointed in 1993. The respondent Mohammed Shafiul Haq, this is my lord, respondent 9 present, my lord, is also a language teacher appointed in the year 2002. That as per section so and so, my lord, that is the act, provides for provincialization of one language teacher along with one social science teacher and one mathematics science teacher. Therefore, as Mohammed Abul Hassan, this is my lord, respondent 10 whom I am representing, my lord, is a social science teacher appointed in the year 1998. The petitioner has been able to demonstrate a good prima facie case for requiring the Director of Elementary Education to revisit and reconsider the claim of Mohammed Abul Hassan for provincialization of his service as social teacher in Kesavita Ami School. The claim of the petitioner as social science teacher is not disputed in the interlocutory application filed by the respondent number 5.
Who is the petitioner here?
Yes, my lord. And both of them belong to my lord.
It is pursuant to this order that the order.
Absolutely, my lord, the impugn order has been passed. So, my lord, my respectful submission, my name should be struck off from this particular proceeding. Because now the appointment, my lord, letter is, my lord, on the verge of, my lord, issuance. And this, my lord, will come in the way, my lord, of the appointment letter. This is a fight between them, my lord. I have been unnecessarily dragged in, my lord.
Against this order, no appeal has been.
No appeal has been filed.
I have time, my lord.
Appeal.
Yes, your lordship.
Then what is the order in the appeal?
No, my lord, I have filed against the my lord respondent number, my lord 1 matter. My lord, I may be allowed to point out, my lord, could come to page 66 matter. It will be more clear, my lord. Page 66 matter.
First, come and tell us at page 78.
Page 78 matter.
This is filed by whom? By you.
Yes, your lordship.
As an, the IA is filed by you.
No, my lord. I have filed the respondent number 9 matter.
Respondent 9. You are arrayed there as.
Yes, respondent 4, page 78,
Number
respondent
4.
4.
Now, there is a finding of this court, para 5,
My lord,
as to who is the what subject teacher.
my lord.
Against this order, has any appeal been filed?
No, my lord. No, this has again finality, disorder.
Madam, can you see, madam, page, madam, 73, madam. Page 70. Sorry, madam, half, madam, page 79, 69. Page 69. Is a madam, report of the madam district scrutiny committee, madam. Madam, can you see first 2 page, madam, outside? Madam, page
We'll
70.
examine all this. Had learned counsel to the parties, issue notice within 4 weeks. Mr. Kaushik appears for respondent numbers
1, 3, and 5.
1, 3, and 5.
So 6 and 7.
1, 3, 6,
5, 6 and 7.
5, 6, and 7. Mr. Pegu for
Respondent number 4.
respondent number 4. Mr. Gogoi for respondent number 2. Then Mr. Talukdar.
Madam, correspondent 10, but also will make some observation. Madam, I have hardly 1.5 year, madam, that's my
Respondent 10.
Madam,
Since learned councils never entered appearance for the respective respondents. Notices are waived, however, extra copies will be furnished within 1 week from today. Issue steps on other respondents by registered post within 1 week from today. The issue pertains to the provincialization of the petitioner vis-a-vis the claims of the private respondents. The matter will require examination. Any provincialization which is done pursuant to the Indian order dated so and so shall be subject to the outcome of the petition.
Madam, one post, maybe, your lordship, as per.
It's for provincialization. So it will be subject to the outcome.
Even, my lord, section 3,
my respectful submission, the pendency of this petition shall not be a bar for issuance of the appointment
We are
letter.
not issuing a stay order.
No, my lord, what the respondents will do, my lord, having regard to the pendency, my lord, they will not issue any appointment order.
Let them do, then you come, we'll clarify.
My lord, apparently your lordship will see, he belongs, my lord, to English section. I belong to social science. Under the scheme, my lord, he cannot. my
We
lord,
are
they
not
will-
issuing any interim order, Mr. Counsel.
They will interpret in a manner.
Why are you presuming?
Madam,
Mr. Kaushik, why do you interpret anything more than that is there in the order?
no, I am asking for a innocuous observation, my lord, the pendency will not bar. My lord,
Observations are never innocuous.
my lord, in fact-
Either we say or we don't say.
in fact, your lordship will see, my lord, he has not been able to.
We have not issued an interim order. This order stands. We are saying it is subject to outcome of the writ petition.
Okay.
We are issuing notice, we'll hear.
Yes, yes, correct.
If pursuant to this, the authorities refuse to issue on the ground that pendency of the writ petition, we have not issued, you project it before us, we'll take care. Why make a observation which as on date is not necessary?
Well, he has to again come, but only if
Who has to again come?
respondent 10 has to again come.
Not necessary. You are there as a respondent on
No, I have to
caveat.
file a separate writ petition, my lord,
When?
in that case.
No, you point out in this matter. Why are you presuming that they will not issue?
No, I leave it to your lordship, but my lord, what I say, my lord, he has.
Yes,
Otherwise, the order of the section is very clear. Has already settled the.
no, that's not the issue. The question is there any ambiguity in the order that we have passed? So they will issue, don't worry.
Normally they interpret, my lord, in that.
They normally you bring it to us, we clarify.
Item number 53.
53.
This case, you will petition of the it's a matter of high school. And the second round of investigation, earlier, we find the first order with the case 85. Earlier order.
85.
85.
Filed by whom?
Filed by the petitioner.
What was the direction?
Because remanded back to the director, holding that respondent number 5 doesn't have the BA degree, so he is not qualified. And it was further held that the petitioner also was qualified because he did not have the teaching experience. And therefore, the director was directed to pass an order, my lord. But instead of passing the order, my lord, the respondent I has been appointed again as the in-charge headmaster of the school
By which order?
by order at page 93, my lord.
93.
Yes, my lord.
But you were allowed for holding academic charge
Yes,
in 92.
yes,
Then
yes, 93, my lord. He has been appointed again as the in-charge headmaster of the school, my lord. So he does not have the PhD.
and where is the earlier order of the court?
Earlier order was issued by page 87, my lord.
80.
87, 11 portion, my lord. It starts from my lord, page 85. Page 87. Paragraph 4.
You have also not completed.
Well, the state, my lord, have completed the existing experience, my lord, but
10 years.
the order, my lord, in place that I did not complete the 10 years of experience.
That's an order. You have not come in review.
That is true, my lord. So, my lord, a review petition has been filed against that person. Because the failure of work.
Heard learned counsel for the parties. Mr. I so here, Mr. Sharma. You Sharma for respondent number
1, 2, 3, and 4, my lord.
1, 2, 3, and 4. This petitioner is before the court for the second time. We agree by the orders of the director's secondary education. As he was not permitted to hold the charge as the headmaster of each school,
Tilapara High School.
Tilapara High School in the district of Udupi. So, earlier, by order dated 28/07/2022, passed in WPC 278 of 2022, filed by the present petitioner. The Director of Secondary Education was directed to decide afresh the issue of grant of the issue of appointment of the petition the respondent on number 5 therein as the headmaster in charge of the same school in terms of the provisions of Rule 14 within bracket 2 of the rules of 2018. So, learned counsel for the petitioner submits that the respondent number 5 does not have a BA degree and therefore under the rules is not qualified to hold the regular post. So, he however submits that the order of this court dated 28/07/2022 passed in WPC so and so and reflected that the petitioner has not completed 10 years of experience, teaching experience, which the petitioner submits was incorrectly recorded because of wrong submissions made, and for which the review petition, you have filed it,
This filing.
is being filed for seeking correction. So, learned counsel for the petitioner submits that he has completed 10 years. And he also is a B.Ed, and therefore he ought to have been given the responsibility of the in-charge headmaster. Better. Having heard learned counsel's issue notice, returnable 4 weeks. since Mr. Sharma appears for respondents, one notice is waived. Extra copy is reserved within 1 week from today. Steps on respondent number 5 by registered post AD within 1 week from today. Now, who will hold charge if you state?
Inspector of schools, give us holding the charge. These all.
In view of the submission made by the petitioner that he has completed, he satisfies the requirement of eligibility of, he satisfies the requirement of 10 years of teaching experience and also having a BA degree. The impugned order dated 14/4/2023 shall remain stayed until the next internal date. Respondent 5 is permitted to file. Since this order has been passed, ex parte respondent 5, they are at liberty to file any application seeking vacation, modification, alteration of this order. List on 15th of September.
Item number 54.
Yes.
Here I have got the terrorist government. Why we like to file that within by tomorrow and when on Monday it will also take some. Otherwise, when I can place the terrorist.
File it, file it.
For 1 day.
I think these classes are supposed to be on 1st of September.
Before that, it can be on Tuesday for you.
Mr. Gogoi, Learned Standing Council held submits that he has received instructions he'd like to bring from the within 2 days.
Yes, sir.
Mr. Ganguly submits there is some urgency in the matter, therefore the matter be listed next week. Accordingly, let Mr. Gogoi will file the affidavit by
By tomorrow I can file.
Friday. Friday is a holiday.
Yes, but by tomorrow I can file. So let's
File it
approximately
within 2 days.
Can it be on
Matter be listed for consideration on 22nd. Mr. BK Boydor appeals for respondent number 3.
For implement of party item number 13.
Anyone for the other earlier respondents? Any objections? Heard learned counsel for the parties. This application is for implement of the names of the officials mentioned in para 5 in the content petition number 373 of 2020. So, learned counsel for the petitioner submits that the officers mentioned in para 5 of the IA are presently holding charge. Are presently the present incumbents of the respective departments. And therefore, they are necessary to be imputed as part of it. So, Mr. T. Chisti, the council appearing for respondent number 4. Does not object. The IA is allowed these respondents. Why do you want to strike out the earlier persons?
Yes, they are no longer.
Let them remain. Are the officials mentioned in this paragraph 5 of the IA are directed to be arrayed as respondents number 5 and 6. How many are there? 2. 2, 5 and 6. In content petition number so and so. The learned counsel for the petitioner will file amended course title in the registry. IA is accordingly therefore allowed and disposed of. Then in content petition, in view of the order dated passed today in IA number so and so, so and so and so and so are arraigned as respondents number 5 and 6. The learned counsel for the petitioner will file amended post title in the registry. Matter will be listed after 2 weeks.
But they mean, because it's 20 meters.
25. Based on 20, no. 11th September.
For admission, I think 14.
Yes, Mr. Osmani.
So, madam, thing is, madam, I was one, though I was in senior madam, my case was not coaching like for police like.
You did not go before the tribunal.
No, is probably 2 issues are here, madam. First, madam, I was terminated, madam. After, madam, I filed an application for not including my name in the police list. I was told that you are terminated from the service, and it is an admitted position of factor. I was not given any vacation. So, my as per that, the prudence has been my.
That has not been challenged.
Absolutely.
Where?
What we.
As per the Fulton judgment,
It's it's maintainable, madam. My prayer is madam at page 23, madam. It starts from page 20, madam. It reminds us that we have to most respectfully pray that your lordship would respect these to admit this petition. Which we are doing calling upon the respect to support that why we in the nature of tertiary should not be connecting the respondent to coincide the service of the petitioner as an assistant teacher of the teacher to retrospective aspect of Nalbari and this school in place of respondent number 11 number 1 by quoting the resolution that is manner. By this resolution, I was terminated manner. That is 17/8/2006, discharging the petitioner from service. From service and include report dated 15/12/2014 by holding them to be illegal and also causing the provincialization order provincializing the service of the respondent number 11 of the in the Nalbari and school. So, my report the issues are now this that when my last. As per the I would like to my place one development of this report my lord in a similar issue. Also make analysis.
let us see the report. The impugn report in 2014. Where is the report?
My lord. Report my lord, which was my lord. I was my lord, continuously my lord answering the letter, my lord, and in the end, my lord.
No, where is the report that you are challenging?
Yes, my lord.
Report.
Yes, my lord. At my lord, page 56, annex 13, my lord. It is personal to my lord, application, my lord. May read my lord. At page 56, annex 13, my lord. Sir, which reference to the subject and the letter number cited above, I have the honor to submit here the detailed report in respect of the events of Mr. Madan Talukdar on non-provincialization of his service against company and his school under Botani educational block. As on the hearing, that a hearing was conducted in regard, in this regard, in presence of SMC president and this of this school and Madan Talukdar on 4/9/2014. That as per the hearing and the statement and other related documents submitted by extent of the Nalbari and his school, it has been found that Sri Madan Talukdar was appointed in school in 1990 and accordingly he joined in the school on 3/3/1990. That as per inquiry report of the BO Bodani, it is found that Sri Madan Talukdar was unauthorized absent in the school with effect from January 2006. The inquiry that is 15/3/2013. As a result, which Madan Talukdar was discharged from his duties by SMC as per resolution number 1 of the executive committee of SMC held on 17/8/2006. But in this regard, no notice was issued to Madan Talukdar.
So my lord, say this is that my lord. And only my lord, pursuant to this report was given my lord, pursuant to an RTI application, my lord. Report direct or regulatory application, my lord. And my lord, immediately after that, my lord, I have submitted two representation, my lord, against this, and thereafter I have put this on our report into the captain. And my lord, lordship will find my lord, that judgment, my lord. My lord, that judgment, my lord, I have just told to your lordship, my lord. That my lord, that judgment is, my lord,
Paragraph.
my lord, Para 18, my lord.
Era
Para 18, my lord. 18.
1/8.
Yes, 1/8. From the aforesaid letter, it is not apparent that there was total non-compliance of procedural requirement laid down under the Act of 2006 and the rules framed thereunder before issue of an order of termination of service of the petitioner. Therefore, the present is a case where the service of the petitioner has been terminated by violating the statutory provision. As such, in view of the full bench decision in Abdul Ghaffur Mondal's Supra, the petition would be maintained. Para 44 of the that judgment, because my head, if there is procedural level, then repetition is maintainable. And if I read my lord, this judgment, my lord, this is my lord.
Yes.
Similar to my case, my lord, and my lord, and on the basis of this judgment, my lord, another judgment was.
You were terminated by whom?
My lord,
In this matter, who terminated the petitioner?
in this matter, my lord, SMC, my lord. My lord, I was, my lord, what happened, my lord, when.
In this judgment,
Yes, my lord.
what are the facts of the case he was
My
appointed?
lord, from page 11, my lord, the facts of the place, I may be allowed to read, my lord, page 11, para 11, my lord.
No, you read from para 2.
Oh, in case of the petitioner, basically it is earlier appointed as an assistant teacher of the Kodomani Pathar English School Madrasa on the strength of a resolution adopted by School Magazine Committee on 3/3/2004. The appointment of the petitioner to the post of assistant teacher, which effect from 3/3/2004, was thereafter approved by the respondent number 4 in the district elementary education officer height order dated 3/11/2005. The petitioner was the fourth elementary education officer height order dated 3/11/2005. The petitioner was the fourth assistant teacher in the same school. However, since the two other assistant teachers senior to her, Mohammed Abdul Hamid and Abdul Sudin, were no longer in service under the school, hence the petitioner had become the second assistant teacher and was entitled to provincialization of her service. However, instead of keeping her as the second assistant teacher, the respondent number 5 had manipulated the records and shown his wife, that is the respondent number 7, as the second assistant teacher in the school, with the sole objective of depriving the petitioner of her legitimate dues. Simply thus, the petitioner has approached this honorable court by finding the petitioner so and so entirely praying for direction for restoration of her service as assistant teacher in the Kodomani Pathar English Madrasa, and also for regular payment of her salary. In the aforesaid petition hearing number 4800 of 2011, the school authorities find a counter affidavit entirely accepting that the service of the petitioner was terminated on the strength of the resolution of the managing committee adopted on 2/3/2009. Same case, same case. I was also finding the management responsibility behind my back, which was never served to me, and it is applicable position of fact, no notice was served, and in this judgment itself, the provision of para 14, provision of rules for 19 of the rule 19 of rule 2007, 2007 rules, at para 14, Rule 19 of para 40 minor family. Rule 19 of the rules of 2007 makes it clear that dismissal from service is a measure of penalty. And as per Rule 20, the disciplinary committee is required to conduct the inquiry in respect of the service because of the disciplinary report to be drawn against an employee and submit a report to the disciplinary authority. From the record, it appears that on 23/2/2019, respondent number 5, that is the headmaster of the school, had issued a communication to the petitioner to the following notice. This is the notice. According to the learned council appearing for the school managing committee, the notice dated 23/2/2009 was a scope of notice issued to her. However, from a provision of the same notice, it appeared that the same does not contain any such. So, madam, this is the notice, madam. Now, the provision, my lord, provision is here at para 13. Para 13, my lord, so we kindly for, madam, the procedure, my lord, for imposing penalty. At para 13.
This is under the 2006, 2007 rules.
Yes, my lord. And para 13, my lord, the Act of 2006 has framed the regulation. Framed to regulate.
Act of 2006 came when? When were you terminated?
Yes, ma'am.
When were you got terminated?
My lord, as per their contention, my lord, I was terminated on my 2006.
And what provision according to para 18 has been violated of the Abdul Ghafur Mandal?
Well, seriously, my lord, whether there is a rule or not, my lord, I am, my lord, they are supposed to give me a notice before imposing any penalty. And my lord,
Yes,
Okay, that is, as far as the department standards concerned, okay, disposal of and sending of, there's a mechanism under the new act, okay? These kind of disputes which arise for.
which new act, which act?
17 act, Lordship, section 14.
Hmm.
Lordship, disposal of the matter,
Hmm.
since it's right there both the parties can be heard, my lord. We can be given a chance to basically.
Where is that provision? Where is that provision?
Lordship, it's at page 123 of the green book, the 79. Appellate authority,
123,
yes, Lord.
yes.
Appellate authority, 14. The state level scrutiny committee shall be the appellate authority against.
Okay,
any-
they will scrutinize whether the recommendation is correct or incorrect.
Incorrect.
But your department admits that he was terminated without notice. What steps have you taken against that?
I mean, that one, I have to get my instructions.
What instructions are received?
and my lord, as per this, my lord, judgment, my lord.
I have-
Last line, my lord. My lord, I am not inclined to dedicate the petitioner to be a different tribunal at this distance for the.
Page number 56
Ma'am.
is an order passed by whom? DEO, District Elementary.
My lord.
What happened after that?
My lord. Hereafter, my lord, I have tried two, my lord, representation, my lord, one to Directorate Elementary Education, my lord. And thereafter another to my lord, school managing committee, my lord. Nothing happened, my lord, till date.
Mr. Fuban, what decision has been taken on the letter at page 57, 56?
56, no. That's why I've got one instruction, I'm sending it now.
Okay.
This is, I just received it. I'm allowed to read it.
Yes, read.
Uh,
What is the name of the petitioner here?
To Madan Talukdar.
This is with regard to some contempt petition.
Here, Lordship, I just read it out, Lordship, I sent a copy in the mail.
Read, yes.
So with reference to the subject matter, I would like to state that, however, in this connection, it is mentioned that the district scrutiny committee Kolkata has recommended the following teaching staff of Nalbari, any school for provincialization of services as per Provincialization of Services Act 2011. as amended, which was submitted by the DEO. In this recommendation, also his name is not there. His name is not there.
Of course, it is not there because he was terminated. Therefore, he is not considered.
But Lordship, that.
Now your DEO has,
I
your
don't get the instruction, I don't have it.
kindly come to page 56.
Lordship, I've got it.
56, there is a finding that he was terminated, no notice was issued.
That I agree, get my instruction. That I don't.
This is a letter of 2014.
Come after a long time, actually.
Huh?
Matter also has come after a long time.
So it's the fault of the court.
No, Lordship, I would have to, Lordship, fix it after a week, Lordship, immediately I'll get the required instruction as to the termination. Because what they have said, Lordship, yesterday is the.
We are fixing it on Monday, you get your instructions.
Monday.
Monday.
I'll get it.
List taken on Monday, enabling Mr. Fukan, Learned Standing Council Education, from taking instructions with regard to the steps taken by the department pursuant to the communication dated 15/12/2014 issued by the DEEO, Borpeta, to the Director Secondary Education. Wherein it is stated that the petitioner was terminated by the School Management Committee on 17/8/2006. But no notice was issued to the petitioner. As a consequence thereof, his name was not furnished by the school authorities for provincialization. Stop. Let these instructions be placed before the court. Again on. All right, we'll take it up on 23.
One more thing, madam, I would like to put up. Madam, this particular, madam, I have given it, madam, inspection report, madam.
If you are terminated, how are you working?
Pillar in 2014, madam. I was running pillar to post, madam. We are, madam, representation after representation. No
You are not-
one that I was good for 5 years.
No, where did you receive your salaries?
Madam, I was not receiving salaries, madam, due to the fact that, madam, the financial assistance also given to my private assistant.
All right, let him come back on 23rd. We'll see what can be done. Please on 23rd. You knew you were terminated, you did not come.
Well, in 2014, I came to know, madam, and immediately, 2015, madam, I have, I came to police, madam, only 2000, madam, I have given a specific, madam.
23rd.
Time being item number 51.
Yes, Mr. Chaudhary.
The matter relates to provincialization matter. What has happened in this case, my lord? The district level scrutiny committee recommended the case of the present petitioner. And respondent number 5 was, my lord, constituted to be an excess teaching. So thereafter, my lord, the recommendation of the district level selection committee, according to the provisions of the act, my lord, it should have been challenged before the state level in terms of section 14, which was not done. Then, my lord, they filed a suit. Now, suit has been decreed. Now, my lord, suit under section 19(1) can be filed only with the approval of the government. Please have the act for a moment, my lord. I'll come to the merits. The 2017 act, my lord. My lord will first come to page 123
Yes,
of the book.
section 14.
14, my lord. The state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee. And state government in the concerned administrative department shall be the appellate authority against any recommendation of the state level scrutiny committee. So since they are agreed by the recommendation of the district level scrutiny committee, they should have preferred an appeal, which they did not do. Now, there is another remedy provided. Please come to section 19 at page 124.
19,
19.
yes.
no suit proceeding or other legal proceedings shall lie for anything done in good faith, done under these acts, except with the previous sanction of the state government. It is something like 80 CPC matter. You have to file a suit against the government, my lord, the notice is a mandatory. Exceptional circumstances, of course, my lord, sometimes it can be waived. And under subsection 2, my lord, they derive the normally this tribunal is the district judge. District judge, my lord, the procedure prescribed in section 19(2) is followed. Now, this was not done. According to me, my lord, in my humble submission, therefore, this suit is not valid. Now, my lord, let us come to the merits.
Yes.
Now, what had happened, my lord? The petitioner before your lordship, my lord, he is a graduate with royal combination, physics, chemistry, and mathematics. A respondent number 5, who filed this suit, my lord, his combination is, my lord, maths, chemistry, and zoology. And respondent number 6, his combination is botany, zoology, and maths. Now, my lord will kindly come to the recommendation of the district level selection committee, which your lordship will find at page 24.
Yes.
The district level scrutiny committee recommended serial number 5, that is respondent number 6. And my lord, 6 is the present petitioner, Rahman Ali Ahmed, and BSc Royal, he is BSc Bio. Now, what happens, my lord, if the combination is followed, then, my lord, it conforms to the SEBA curriculum. If your lordship will kindly come to page number, my lord, 113.
The paper book.
Yes, 113.
Yes.
The subject combination of BSc teachers shall be such. Then all BSc teachers taken together shall cover 6 weekly periods in mathematics, 2 periods in physics, 2 periods in chemistry, and 2 periods in biology part 6. Then, my lord, will kindly come to next page, page 113, note number 5. BSc teachers shall be so selected that their subject combination cover all major branches of science and mathematics. Now, why the district level scrutiny committee selected petitioner in the respondent number 6 is very clear, my lord. Now, the situation is like this, my lord. If respondent number 5 and 6 are selected, it's an admitted position, my lord.
You are royal,
I'm right.
PCL,
PCM.
and number 5 is
Number 5 is maths, chemistry, zoology. And number 6 is botany, zoology, mathematics. Therefore, my lord, if 5, 6 is given, because both of them are senior, my lord, then what happens? The students will be deprived of physics and biology teaching.
no. If 5 and 6.
If 5, respondent number 5 and 6 are, my lord, provincialized, then, my lord, students will be deprived of
Physics.
teaching in physics and biology.
No, biology is there.
Yes, my lord, not there.
Zoology.
Huh?
Zoology.
No, 6 has gone. So therefore, authority has given 6 and the petitioner, not respondent number 5, who went to
6 has botany, zoology,
Yes,
and maths.
nice. So if 6 and petitioner is given, then all subjects are covered. If 5 and 6 are given because they are senior, both of them are senior to me, my lord. In that case, the students will be deprived of, my lord, physics and biology.
Physics and chemistry. Physics.
Biology,
Physics.
Only physics.
Only physics.
Physics, sir, yes, physics. Now, my lord, the other day the matter was taken up, my learned friend appeared for the respondent number 5. His contention is under the 211 Act. My lord, it was seniority which matters, and it is a fact. There are judgments of this honorable court where it says one has to go by the seniority. Now, my lord, my lordship knows 2011 it has been struck down. Now, please have the book, my lord. Come to the repealing provision. Please come to page 126. Yes, there are judgments under 211 Act, seniority was the criteria, but under 2017 Act, it is the subject. Section 24. Assam Venture Educational Institution Provincialization of Service Act 2011, as amended by the Assam Census Act of 2012, and Assam Venture Educational Institution Provincial Services Amendment of 2013, which have been struck down by the Guwahati High Court by order dated 23/9/16 in WPC, and all the rules, orders, notifications issued thereunder shall stand repeat. However, all teachers whose services were provincialized prior to 23/9/16 shall continue, and their cases will be reviewed as per the eligibility norms set forth in the Provincialization Act. First of all, my lord, Section 24 is not a savings act. It is only a repealing act. When an enactment is repealed, my lord, unless there is a savings provision, my lord, there is no question of any vested right being continuing or accrued right being continued. Now, what it says is, if any provincialization is made prior to 23/9/16, in that case, their cases will be continued, but it will be reviewed as per the eligibility norms provincialized under this act.
So the saving will apply only in cases of teachers being provincialized
Yes.
prior to so and so.
Yes.
Your case
Respondent
is-
number 5's case was never provincialized. Now, their case, which is will be projected, my lord, that under the 2011 Act, the seniority was the issue, not the subject combination was not the issue. And in fact, on 2011 Act, there are judgments of this honorable court, even division bench will also say that in case under provincialized under 2011 Act, it is the seniority which matters. But now,
And in this present rules, what is the criteria?
yes, section 4 minus.
What is the school?
Yes. School is a high school,
High school,
yes. Please come to 114 minus.
114. Yes.
Subject to fulfillment of all other provisions of this act, the services of teachers and tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. All teachers to be provincialized under must have been working as a teacher in the concerned venture education institute as mentioned in section so and so that have been recognized by the competent authority, must have the minimum educational and professional qualification as laid down on the different acts, rules and regulations as mentioned under section 6, must have rendered at least 6 years of continuous service as on so and so from the date of joining in the concerned venture education institution, which must be on so and so. In case of teachers like so and so, so and so, so and so, the number of students appeared in concerned final examination like HSLC, etc. conducted by SEBA or a Assam Higher Secondary so and so, as the case may be, shall not be less than 10 students in per each class per year during the last year. Now, I lordship, have your lordship kind attention to 2011 Act, my lord, for a moment.
No, what is the criteria under
Yes.
4?
Now, if you lordship to kindly come to 647 for a moment.
Yes, 647.
Yes. Yes, please come to section 4 at page 653, my lord. 1 second, my lord. Under the 2011 Act, seniority was the criteria, my lord. Anyway, my lord, what is now here the criteria in section 4, my lord, under the new act. Now the SEBA regulation is a relevant consideration, my lord, and district level scrutiny committee recommended the case of the petitioner and respondent number 6 because, my lord, they conform to the prescription of the SEBA regulation. Now, if the respondent number 5 and 6 on account of seniority is to be given, in that case, my lord, the students will be deprived of teaching in physics. So having regard to that relevant aspect, the petitioner and the respondent number 6 was recommended. Now, my lord, where is the right of the other side to claim provincialization under the 11 Act? 11 Act is no longer there. If you would have been regular provincialized prior to 23/9/16, things would have been different. So the provisions of the Act has not been saved.
Yes.
In fact, my lord, if your lordship will kindly come to page section 4, Roman 3, must have minimum educational and professional qualification as laid down under different acts, rules and regulations as mentioned under section 6 or any other relevant statutory provision as the case may be. Now, SEBA regulation is a regulation, my lord. If in a case under, my lord, 2011 Act, then of course seniority would have been a relevant consideration. But that Act is no longer there. Now, if your lordship will kindly come.
Under the new Act,
Yes,
according to you, the criteria would be in terms of the,
regulation, my lord, amongst others, all acts, regulation.
where is that provision?
At page section 4, Roman small 3, my lord.
Page number
1 second.
114, 115.
Yeah, 115.
Yes.
Must, Roman 2, in fact, I'm sorry. Must have minimum education and professional qualification as laid down on the different acts, rules and regulations as mentioned under section 6 or any other relevant statutory provision as the case may be. It's very wide. If your lordship will kindly come to page 114, my lord.
Yes.
This is an order issued by the Director of Secondary Education, my lord.
114.
114.
Yes.
Provisional departmental recognition for
Yeah,
class
114.
114
Oh,
of the repetition.
okay. Yes. Yes.
And see, my lord. Serial number 2. Admissible number of teaching and non-teaching staff. Pre-class high school 8 to 10, 1 headmaster, 2 assistant teacher with BA BCom, 2 assistant teacher with BSc, 1 with physics, chemistry and mathematics combination, and other with botany and zoology, / 1 senior Hindi teacher, 1 classical teacher, and 1 LDA and 1 grade. So 1 teacher has to be with, my lord, physics, chemistry and mathematics combination, and other with botany and zoology. As far as petitioner is concerned, my lord, district level committee was absolutely right. Yes, it was the district level committee's recommendation was under the 2011 Act. In fact, that was the time when, my lord, and in regard to the SEBA regulation, recommendations were made. But my lord, this honorable court took a view that since seniority is the criteria, therefore subject combination may not be relevant. But now that act is gone. So those judgments will not have any relevance here. Now we are governed, now if at all one claims, my lord, provincialization, it has to be under the 2017 Act. So seniority has no role. It is the subject combination which is more important, my lord.
Now, what will be the effect of a title suit?
Now, title suit, my lord, that is, my lord, void ab initio, because number one, without sanction of the government, suit cannot be instituted. That is gone. So Lordship will examine the matter, my lord. Lordship will stay the suit, my lord. And the pursuant to the decree, my lord, the case of the respondent number 5 should not be considered for the present. That is my humble submission.
Yes.
My lord, let's go to the root of the matter. If my lord can have that. Assailing the provincialization of respondent, the petitioner and the respondent number 6 here. And the respondent number 6 here. I had instituted WPC 2913/2013. Now, in the meantime, my lord will have this order is dated 26/5/2017. When I move this act, my lord, if your lordship can come to the 3rd page, 2nd paragraph.
Yes.
This court, while issuing notice to the respondents on 27/5/2013, in the interim specifically directed not to grant the benefit of provincialization of the said Act of 2011 Act, as per respondent number 5 and 6, to the respondent number 5 and 6. That is, my lord, the petitioner here and the respondent number 6 here. In the meanwhile, the state government in the secondary division sanctioned 10 posts for provincialization of services of teaching and non-teaching staff of so and so, pursuant to this directed by its order, it allotted those posts to so and so, with effect from 1/1/2013, which also includes 2 posts of science graduate teachers. As because of the interim order was in force earlier, passed earlier on so and so, the respondent number 5 approached the honorable court by way of filing so and so for vacation of the said order dated so and so. Though the interim order dated 27/5/2013 was vacated by this court in MC number so and so, but subsequently by another order dated so and so, passed in so and so, the benefit of provincialization of services of the respondent number 5 was stayed until further orders. The petitioner's main contention is that he was shown as excess assistant teacher, although he is the most senior-most teacher in the school, which was negated by the respondent number 5 and 6. Then my lord would say, Abdul Ghafoor's judgment is taken into note, and the constitution of the education tribunals are brought. Then my lord, 2nd paragraph. Since the services of the petitioners and the respondent number 5 and 6 have not been provincialized yet, this court is of the view that seniority dispute of the petitioner and the respondent number 5 and 6 should be considered by the concerned education tribunal. It is worth mentioning that the government in this so and so, after the act was declared unconstitutional by this court, enacted a new act under provincialization, namely so and so, which came into force with so and subsection 219 of the said act also specifies about such education tribunal. Considering all this, the petition is directed to approach the appropriate education tribunal to determine the issue of seniority between him and the respondent number 5 and 6 for provincialization of his services as science teacher in the school in question, which has already been provincialized by order dated 26/7/2013, issued by the DSC Assam, wherein 2 posts of science graduate teacher are yet to be provincialized. In the event of such approach by the petitioner before the education tribunal, the concerned education tribunal shall dispose of the claim of the petitioner at an early date by giving an opportunity of hearing to the present respondents 5 and 6, as well as the managing committee of the school in question, including its headmaster in accordance with law. Now, in terms of this direction, my lord, I approached the tribunal. While filing the claim, my lord, 19(2) was there, but it was not a case under the 2017 Act. It was a case under the 2011 Act. Once the tribunal has decided the seniority, now, my lord, the consequence would be that the appointments have to be made in terms of seniority. Now, the petitioner has right.
That assertion, where do you get it from? Well, it has to be on the basis of seniority.
Yes. Because, my lord, that seniority dispute has been directed, because I'll explain.
Seniority
provincialized.
was to be directed, was to be decided between you and the respondents.
Lordship.
Tribunal has done it. Holding you to be senior than the respondents. Now, the mandate of the right of the rules to say that it is only on the seniority that provincialization is to be
Lordship will come to 654.
654.
Lordship.
211.
And under similar circumstances, I will place judgments. How this, how they go. Rule 2, 4.2 actually. The number of employees in both teaching and non-teaching cadre in each so and so. Services of whom are to be provincialized under this act shall not exceed as specified in the appended to and so. Now, this is important. Provided that where the number of such employees serving in such venture educational institutes exceeds the number as specified in the schedule, the provincialization of services of the employees shall be on the basis of seniority in the respective category in that concerned educational institution. The state government shall not have any liability whatsoever in regard to such excess employees. Now, my lord, the category, my lord would find 6. Lordship. My lord will have the schedule at 663.
Yes,
My lord would have high school,
high school,
lordship. Next page, 664.
high school and high madrasa.
High madrasa, well, it's same
Classes,
category of stuff. My lord has got it.
two
Down
classes,
will,
two classes.
but 2 classes,
Yes. Then,
5 classes also. Assistant teacher science,
no, you fall under 2 class or 5 class.
2 classes, 2 class, 2 class. Assistant teacher science,
Right.
that's a category. So within that category, it will be the seniority, not the subject combination. Now to come to that conclusion, well, there are single bench judgments,
Let us come back to 4.2 proviso.
provision. 654. Provided that where the number of such employees serving in such venture educational institution exceeds the number as specified in the schedule, exceeds. So if there are, it's only 2, more than 2 in that category, the provincialization of services of the employees shall be on the basis of seniority in the respective category.
So is it seniority for these 2 posts or seniority when it
For the-
exceeds?
No, when my lord, there are 3 or 4 subject teachers in science. Then my lord, actually, it's already
Let's come back to the proviso.
scheduled.
No, proviso.
Provided that where the number of such employees serving in such venture educational institutions exceeds the number as specified in the schedule.
So the schedule, if we come back at 664
Lordship,
for assistant teacher science,
lordship,
this is a 2 class.
2 class,
So how many teachers?
single section, it would be my lord 2.
So in your case, which is applicable?
My lord, will be science teacher will be 2. 2 science teachers
So
will
it
be
is-
provincialized.
If you have more number of persons,
Then if you have more than 2 science teachers, then my lord, the next one. The provincialization of the services of the employee shall be on the basis of seniority in the respective category in the concerned education.
that's what I'm saying. Seniority is to be decided in this 2 class or seniority when you have more than 2. Because
I didn't get it.
see, you provincialization in respect of these 2 science teachers, there has to be some correlation with the subjects required to be taught. So you already have 2 teachers. So you decide who is relevant, who is not relevant for the subject.
That is, cannot be done.
Allow us to understand.
Lordship,
This is one that you decide which of the 2 subjects are relevant. Beyond that, you also have other science teachers or other science subjects.
fine. Got it. So my lord is saying that within the category would mean,
No, I am not saying.
No, no,
I'm
yeah,
reading,
that's-
I'm reading the proviso.
the category is science, language, music, craft, headmaster, assistant teacher, BA. These are the categories.
The proviso says where the number of employees.
Serving in such venture exceeds the number specified in the schedule.
So what is the number specified in this?
Specified for assistant teacher, my lord, it will be 2.
So if the number of teachers exceeds
2.
2,
Then my lord, the next one.
then
The provincialization of services of the employees shall be on the basis of seniority in the
So
respective
that
category,
seniority is to be applied to the
two. Within that
is it
science
two
teachers.
or is it beyond two?
No. Beyond, my lord, if there are three, say my lord, hypothetical situation, there are four teachers working as for again science, as assistant teacher science in that school. Only two of them will be provincialized. How?
Now then, where is the relevance of the subjects then?
It's not there. That's what I'm saying. It's not there.
How
And
how will the school run?
that's a different thing altogether. I'm sorry, my lord, the division bench of two division benches judgments I have with my lord. I'll just place this. I think one is already defined. Gopen Takoti. Is it what we should do?
Yes.
Gopen Takoti is already there, Manan. Manan has got it. Similarly, this is a judgment of so and so. The intra-court appeal is directed against the order dated so and so passed by the single judge where we dispense so and so. In the school in question, there are three science teachers.
Are you relying on Gopen Takoti?
And one more.
No, are you relying on Gopen Takoti? Because if you look into the name of the respondent council,
Oh, so I'm not relying. I'm not relying, but I'll rely on the other. Manu will rely on the other.
no, you can rely. Why should you not rely? It's a division bench judgment. Why should you?
I need not be, my issue is otherwise covered by a recent board judgment. It's Kishore Kumar Deka.
Yes.
The similar situation I have obtained in my case was obtaining here. Madam.
By Mr. Chaudhary.
Yes, Your Worship. Malad will have para two. This writ appeal has been filed by the writ appellant challenging the order dated. Malad will see the date.
So there used to be earlier judgments, I think.
There are Malad single bench gallop with that this should not be done. It's Malad reads this judgment, I think it.
But there is a judgment where the relevance of the subject was also considered.
Malad, these judgments under the 2011 Act have always been dealing with the saying that the subject is not covered. Malad will have this judgment. This is of 4/3/2021, latest. The writ appeal has been filed by the writ appellant challenging the order dated 28/11/2018 passed by the learned single judge in WPC 5914/2015, para 2,
Yes.
whereby the writ petition has been allowed and the provincialization of the services of the writ appellant respondent in question has been quashed. Then my lord, para 3 says it is with regard to the 2011 Act. My lord would come to the para 4, my lord, relates to the section 4, it quotes 5, my lord. The schedule appended to the Act shows that a maximum number of 3 assistant teacher science can be provincialized in a venture school. And with the school with which we are concerned, Sabitri Bala Barali High School is
I think there was a circular by the department.
that has been dealt with here. 14 circular has been dealt with. I'm coming to that. With the school with which we are concerned, Sabitri Barali High School, District Kamrup, the limit are 2 teachers. Under the aforesaid provision, government passed an order dated 22/9/2014, whereby Sabitri Bala High School, District Kamrup was provincialized, and the services of the following number of teachers were provincialized, which is as under. So, my lord, serial number 6 was the appellant. These services were provincialized. Against the post of graduate teacher science, which we are concerned, one Santosh Borali and another Kishore Kumar Deka, the present writ appellant were provincialized. This provincialized, as far as relates to provincialization of the present writ appellant, was challenged by the writ petitioner by way of a writ petition, stating her claim on the basis of seniority. Her case was that both writ appellant and the writ petitioner were appointed by the order dated so and so, and joined their services on 8/8/94. But it is also an admitted fact that the petitioner, that is the respondent before us, being senior in age, was given seniority over the writ appellant. The undisputed fact is that the respondent was senior to the writ appellant as assistant teacher science in Sabitri Bala High School. This was also contention of the writ petitioner before the learned single judge, which was that she being senior to the respondent writ appellant before this court, it was her services which are liable to be provincialized. As the criteria of provincialization of services of teachers is primarily seniority in service. As we have already referred subsection 2 of section 4 of the Act, which says seniority is the criteria for provincialization, and the seniority has to be considered in the respective category. This is the reading level, which would mean the category of teachers such as science teacher, language teachers, etc. The respondent in the writ petition as well as the state government justify the provincialization of the writ appellant on the basis of the fact that the writ appellant had graduation in physics, chemistry, mathematics, same year, whereas the writ petitioner had chemistry, zoology, and botany as her subjects. Admittedly, she did not have mathematics as a subject in her graduation. Children in school need to be taught mathematics, and therefore they have given preference to the respondent, that is the writ appellant, as against the writ petitioner, as she was not having mathematics as one of her subjects. They have also relied upon the office memorandum dated 7/5/2014, which my lord is preparing in their favor, which also is part of the record in the present writ appeal as Annexure G. The subject of the office memorandum is as under. My lord can just skip that. It says about the subject combinations. Now, para 8. The learned single judge, however, was of the opinion that there were already decisions on the subject by a division bench of this court, where the court have emphasized that the criteria for provincialization of services would be seniority, and it is not with the seniority. The reference is of the order of a division bench dated 5/5/2016, passed in writ appeal number 290/2014, as well as the order dated 31/8/2016, passed in so and so. Mr. So and so, learned senior counsel for the writ appeal, would argue that the proviso to subsection 2 of section 4 emphasized that provincialization is based on seniority, but in the seniority in the respective category, the exact word which has been used in the proviso is shall be on the basis of seniority in the respective category in the concerned education institution. As to what would be the respective category is clear from the schedule, which is given to the act, where in a high school the following categories have been mentioned. Now, para 10. For teachers, therefore, we find that there is a category of assistant teacher science. Assistant teacher science is a very broad category which should include a teacher in mathematics, as there is no separate category of mathematics teacher. In other words, where an inter-se seniority of teachers have to be calculated, the inter-se seniority as a category of teachers of science that could include all streams of science, be it physics, chemistry, botany, so and so, as well as mathematics. Once we take that science and mathematics are as one single category of teachers, there is absolutely no doubt in our mind that between the writ appellant and the respondent, it was the respondent who was senior to the writ appellant and therefore liable to be provincialized. As against the writ appellant, therefore, we find no fault in the order of the learned single judge in this respect. Now, with regard to the memorandum, at this stage, so and so, for the appellant, further argued that the office memorandum dated so and so emphasizes that at least one assistant teacher should be from mathematics, and therefore, when two assistant teachers have to be provincialized, at least one of them be from mathematics. This argument, however, we are not prepared to accept for the following reasons. First and foremost, this aspect has been introduced by way of office memorandum. The office memorandum also categorically states that amendment will be made in the rules, and admittedly, these rules have never been made so. Moreover, the subject matter of the office memorandum itself shows it is regarding recruitment of science teacher in provincial school, and therefore, in any case, this criteria has not to be looked into when a venture school is being provincialized. The necessity of a teacher in mathematics cannot be denied. A school must have a teacher in mathematics, but we are not presently deciding an issue which relates to quality of teachers and the category of teachers to be recruited in an institution. The matter which has to be decided between the parties is as to which teacher has a better claim for provincialization. The purpose of provincialization is entirely different. The purpose of provincialization was to bring certainty in the service condition of teachers who have so far been teaching in venture schools with meager salaries. They are now to get a regular salary, and the liability is taken by the government. And in fact, after provincialization, such teachers become government servants. Their claim is to be tested on the ground of seniority. The purpose of the act is very clear, which is that provincialization has to be based on seniority. Definitely, the seniority has to be based keeping different categories in mind. And as already indicated, science and mathematics together constitute one category. Seniority in that category has to be seen. In that view of the matter, no further scope. So in this view of the matter, my lord, before the learned tribunal, I was relegated to the learned tribunal by this honorable. I went there. So these provisions of 2017 Act coming in will not. Their provincialization was the matter of challenge. That challenge, my lord, this honorable court said that the seniority has to be determined. The seniority before the learned tribunal, my seniority was admitted to by all the parties. In that view of the matter, it is the the respondent number 5 and 6 presently before your lordship, who are eligible to be provincialized, because my lord will see the date. I was appointed on 12/9/96. The respondent number 6 was appointed on 24/4/99. And my lord, the petitioner came in on 25/2/2006. The setting aside of the act, my lord will not negate, because this order of Kishore Kumar Dekar, same thing. It was delivered after 2017 by the writ petition, in the writ petition. The first paragraph, second paragraph.
What is the mandate of the present act now?
A present act, my lord, all will be regularized who have provincialized, who have that qualification. Either a teacher or by, as my lord.
What about the seniority factor?
Seniority is not a factor.
What is the factor?
It's, my lord, whoever are there, if they have the qualification, they will be provincial.
No, in the
Under the
in the
2017.
context of two classes.
Two classes, my lord, if there are 4 teachers also, all the 4 will be provincialized. If they have the qualification, they will become a teacher. If they don't have the qualification, they will become a tutor.
Now, your regularization was in respect of which year?
2011,
Sorry, provincialization.
2011, 2013. The school was regularized.
The judgment of the tribunal is?
The first order of this honorable court is my lord of 26/5/2017, when it relegated me to the tribunal. And the
Because
tribunal
after coming in of the new act.
new act,
Ah,
and the new act came on. The new act came on 11/11/2017, 11/4/2017. And my lord, we'll just have that Kishore Kumar Dekar's case, my lord,
Kumar Dekar,
which I just realized, my lord.
yes.
The second paragraph, second paragraph.
Para 2.
Para 2. The writ appeal has been filed by the writ appealing challenging the order dated 28/11/2018. So that is a decision, my lord, after 2017, 11/4/2017, after the new act had come in.
But it was deciding the it was interpreting the provincialization.
Because my lord, under the provincialization, the school was provincialized under the 2011 act. Wherein also, here also, both the schools have been provincialized under the 2011 act. My school was provincialized on, my lord, I'll just give the date, 26/7/2013, with effect from 1/1/2013.
And what are your prayers here specifically, Mr.
I
Choi?
have to set aside and first the decree, my lord.
The decree of the tribunal.
Yes. And to give effect to the recommendation of my lord, the district level Sputnik.
Then we'll hear because
I'll give a reply, my lord.
subject to correction.
Yes.
Apparently, the issue of the subject preference has been settled by a division bench.
No, my lord. Anyway, my lord, that is his submission. My lord, I'll make my submission, my lord.
Uh,
I'll give my reply to that.
We are issuing notice presently.
No, my lord, I have a point. Of course. Now, my lord, we all know one thing, my lord. That under the 2011 Act, seniority was a criteria. And all the judgments, my lord, which is being relied upon by the other side, these are cases, rightly or wrongly, somebody's cases were provincial life. Unlike in the present case, where his case was not provincial life. Only a recommendation was made in my favor. My lord, a judgment is an authority for what it actually decides. Merely because my lord, division bench of the court has directed the tribunal to consider issue of seniority, that may not be binding on your lordships, if my lord, the correct perspectives are not taken note of. Now, my lord, can we be oblivious of the fact?
We are in session of the matter. We will examine this matter.
Yes.
What I
No, what I.
feel is that
Yes.
the issue of interpretation of this proviso presently
Yes.
has been settled by a division bench.
No. That's why I'm coming. Can you give it to me this time? I know it's a motion, they, my lord, the other matters are also there. My lord, as I said, in all the judgments, you will see somebody's cases were provincialized
Correct.
under the 2011 Act, rightly or wrongly. Authority took the view subject combination is important. This honorable court gave a literal meaning to the proviso to section 4 of the 2011 Act, whereby it is said seniority is the criteria, you can't go by the subject combination.
In
Very well.
17, that criteria is not there.
Yes, now under the 20, no, well, that statute is no longer there. It's not a case of repeal per se. It's a case of where this honorable court has struck down the act. And one of the most important, the provisions have not been seen. So
See.
where is the question of argument based on 2011 Act, my lord? How that argument is even countenanced? 2011 Act, as if my lord, it is never there in the statute book. Where from the question of deriving right from 2011 Act comes, my lord? Is it an argument which is even worth
Now-
considering?
Now, what is the stage of the provincial
No, now
process? for
now
provincialization?
question is, based on the judgment, his case could not be considered. Lordship will decide the matter, based on the judgment, his case cannot be considered.
Now,
Nobody is provincial.
nobody is provincial.
As on date, what they will do in terms of the order,
Alright,
now, if lordship protection is okay.
alright, we'll decide this issue.
Yes.
2 minutes. Just a little.
No, let my understanding complete, then I reply, can't be a running conflict.
We are not, the issue has been raised here, several issues have been raised here, we'll decide this issue.
Manor will decide.
Let us issue notice, let us hear the department, what they have to say.
Fine, but the argument that the 2011 you cannot consider after the 2017 Act comes in, the division bench considered that paragraph.
Division bench, this argument are not made.
We will consider that, we'll consider that. This is the-
I
this is
show
the-
the judgment.
This is the judgment.
But why
of
not
the
will
division
not,
bench.
why not will not bar that order? Because that would be in the teeth of the division bench's order.
No.
Because it's only on the ground of combination that the argument is being met that the order has to be stayed.
We have,
Let it be made subject to the outcome of the case.
we have heard you.
Let it be made subject to the outcome, otherwise why not it is going contrary to the division bench order. This is
So
the
the
argument.
division bench, these arguments are never considered.
Yes, I am sure the judgment Malad where it was considered.
Never considered. That the act is repealed, that this act is no longer there.
Malad will have the single benches order then. I can show that. Wherein everything was considered and it was under the. And Malad would see. The argument that somebody in services were provincialized. In Kishore Kumar Deka services were provincialized in 2014. That was interfered in 2018 by this honorable court.
This is what.
That's what I'm saying. And then the other person was directed to be given from that date.
Because the consideration of provincialized was during the currency of the
My case is same.
earlier.
My case, my provincialization is of 2013, my lord.
It's not provincialized.
Yes, my lord,
It's provincialized recommended.
My lord will, no, it is provincialized. My lord will have that 2913, my lord, second paragraph. 2913, third paragraph. Because that should not be a wrong, my lord, thing. My lord will have paragraph 2 of the third page of 2913, my lord.
What is 2912?
My lord, simple fact is why he went to the tribunal, because his name was not recommended. What is the question of provincialization?
My lord, my case was provincialized, then my lord, I should not have been here. It was his case wrongly provincialized, like in Kishore Deka, the writ petitioner challenged it.
Therefore not provincialized, right here on.
My lord will have the second paragraph of page, third page of 2913, my lord.
What is 291?
That the judgment by which I was relegated,
Page number?
page third page. Page number 3, bottom. My lord, that order which I gave, 2913.
We don't have an order.
My lord, just now,
2913, yes.
my lord will have the third page.
Yes.
The court, while issuing notice to the respondents on 27/5/2030, in the interim specifically directed not to grant the benefit of provincialization as per the said act to the respondent number 5 and 6. In the meanwhile, the state government in the secondary education sanctioned 10 posts for provincialization of services of teaching and non-teaching staff of said Badla Rangapani High School by order dated 25/7/2013. Pursuant to which the director so and so by its order dated allotted those said posts so and so with effect from 1/1/2013, which also includes 2 posts of science graduate teachers. My lord, 2 posts of science graduate teachers already given.
No, before that, you read the earlier paragraph.
Lordship,
Para You can read from first page.
Not the second paragraph.
Second paragraph.
The petitioner as well as the private respondents number so and so were serving as science teachers in so and so since its venture. When the school was taken up for consideration for provincialization under the so and so. Venture so and so, the names of the respondent number 5 and 6 were forwarded for provincialization as science teachers without considering the case of the petitioner.
Forwarded.
Forward, no,
Yeah,
yes. If it is his case that under 200 2011 Act, he was not provincialized, my lord will record that, I'll have nothing to say. If that is the submission, my lord, I'll have nothing to say.
No, this petition was filed by you.
Yes, my lord.
You were challenging the case of the petitioner
Yes.
and the respondent
For provincialization.
being forwarded for provincialization.
Right.
Pursuant to that was a provincialization.
Yes, that provincialization, second paragraph of page 3.
No, my lord, against the decision of the district level.
My lord, my lord. Let's have the facts, my lord, not the, my lord will have the facts.
Page number.
The
Let
third
my
page, my lord.
friends show that my case was provincialized.
I am showing that only.
Yes, yes, please do that.
This court, while issuing notice to the respondents on 27/5/2013, in the interim specifically directed not to grant the benefit of provincialization as per the act to the respondent number 5 and 6. In the meanwhile, the state government in the secondary education department sanctioned 10 posts for provincialization of services of teaching and non-teaching staff of the said so and so by order dated 25/7/2013, pursuant to which the director by its order dated 26/7/2000 allotted those posts also so and so with effect from 1/1/2013, which also includes 2 posts of science graduate courses.
What is the meaning?
As because, my lord will read further, as because the interim order was in force passed earlier on 27/5/2013, the respondent number 5 approached this court by filing NC number so and so vacation of the said order dated so and so. Though the interim order dated 27/5/2013 was vacated by this court in NC number so and so, but subsequently by another order passed in so and so, the benefit of provincialization of service of respondent number 5 was stayed until further orders. So my lord, his case was there. There was a stay order.
We agree. What we want to understand from this order is that the cases were forwarded because of
Exactly.
interim orders.
Ah,
They were never, the provincialization orders.
I
were
know
never
their
passed.
name came, 2 posts were allotted to them and the respondent number 6.
Allotted, what's the meaning of allotted?
No, were sanctioned in their name, my lord.
Was the order of provincialization issued or not?
Yes.
The school was provincialized, my lord. 10 posts were granted. 2 posts
If-
because I had an
Is it
interim
your
order.
case, Mr. Nair, that once a school is provincialized, all it requires for the authority is to allot posts and no further order is
No
necessary?
further, the name, the posts are allotted in their name. That is why, my lord, the second order was passed by the.
Yes.
My lord, the respondent
Department,
number 6 is here. He can say.
department, what do you say? Let us hear the department. Who's for the department? What is the process for provincialization? Is it a case that only allotment?
School was provincialized in the year of.
We are not on the school provincialization. The query of the court is, once a school is provincialized, in the process for recommendation of provincialization of the teachers, is there a separate order for provincialization necessary? Or is it sufficient to say that this provincialization of the teachers are there, we allot so and so posts?
My lord,
Don't tell me you need instructions on that.
provincialization order is required, my lord.
Then. Mr. Nair? Mr. Nair? He says provincialization order is required.
My lord, what
All
am
right,
I?
heard, learned
I
counsel,
just-
CK counsel for the petitioner, Mr. So assisted by, so Mr. U Sharma for the respondents, Mr. Nair, assisted by Mr. So and so for respondent number 5, and Mr. Kayum for respondent number 6. The dispute which arises in the present petition is pertains to the issue of provincialization of the petitioner vis-a-vis the respondent number 5 and 6. Yeah, the provincialization of the petitioner and the respondent number 5 and 6. under the school of, for which school? Which school? Bodla Rangapara High School. Rangapani, sorry, Rangapani High School. So. The claim of the petitioner is that he is an assistant teacher, science. So also the respondent numbers 5 and 6. However, petitioner is a person, is a teacher who's qualified, who has qualifications in physics, chemistry, and maths, and imparts education in.
As a venture state, I am doing matter.
All right. Qualification in physics, chemistry, and maths. Whereas the respondent number 5,
He has got maths, chemistry and zoology.
maths, chemistry, and zoology.
And respondent number 6,
And
botany,
respondent
zoology and
6
maths.
has botany, zoology, and maths. So because of the inter-se seniority dispute arising between the petitioner and the private respondents, the matter came before this court earlier. And pursuant to which order?
One of the 2913.
Pursuant to order
Order
dated
dated 26/5/2017.
26/5/2017. Past year, WPC 2913, the matter was relegated before the tribunal, educational tribunal, stop. The educational tribunal by its order dated
My lord, 31/5/23.
31/5/2023 has rendered a finding holding the respondent number 6
To be senior.
to be senior to the petitioner.
Sorry, respondent number 5.
Is it 5 or 6? Who is
In
senior?
fact, both are senior, my lord. Both are senior too.
5 and 6 are senior to the petition. Stop. It is against this order that the petitioner is before this court, challenging the same order. Stop. The learned counsels, the learned counsel for the petitioner submits that since the petitioner and the respondent number 5 and 6 cases were never considered for, where petitioner and the respondents 5 and 6 were not provincialized as on dates, and their cases have been under consideration before the relevant or competent authorities. The provisions of so and so Act 2011 are not applicable. It is instead the provisions of so and so Act 2017 are applicable,
And even the tribunal has also recorded that at page 82.
and which, according to the learned counsel for the petitioner, has also been recorded by the tribunal.
Yes.
At
Page 82, my lord.
which paragraph?
Somewhere in the middle, my lord, the school has already been provincialized by order dated 27/6.
In
13 issued
para
by the
6.
director, but two posts of science teacher are yet to be provincialized, but kept vacant.
So. Per contra, it is therefore submitted that the provisions of the so and so Act 2011 will not be applicable. Where the criteria for provincialization was on the basis of seniority, rather the criteria as mandated under the Provincialization Act of 2017 will be applicable. It is further submitted that under the Provincialization Act of 2017, the earlier Act of 2011 was repealed, but
No savings.
there is no savings within post clause under the same. Where, per contra, Mr. Nair has strenuously urged that the provisions of 2011 are applicable as the cases of the petitioner as well as the respondents were taken up for consideration by the competent authority during the currency of the 2011 Act. Stop. Mr. Nair refers to the judgment of division bench of this court rendered in Kishore Kumar Dekar, reported in so and so, to submit that this issue has been finally settled by division bench of this court. So, division bench of this court, besides there being getting out this judgments rendered by coordinate benches, As such, the consideration of seniority between between the petitioner and the respondents 5 and 6 will have to be under the provisions of 2011 Act, and the same is on the basis of seniority, and the tribunal has correctly arrived at the finding. As such, the challenge made to the tribunal ought not to be undertaken, and the writ petition be rejected. So. Mr. Sharma, learned counsel for the petitioner, appears for the department, who submits that instructions are necessary in the matter. Mr. Kayum appears for respondent number 6.
I am the second senior most milord, and I have.
You support,
six number.
who do you support?
Yes, we'll see.
Who do you support?
But I have not support either my participation. My case will be considered. But this
Mr.
would be.
Kayum appears for respondent number 6,
He is alone in this case.
who submits that. What do you submit?
But
That while the provisions of the Act of 2011 are applicable, nevertheless,
because
it is the respondent, your respondent 6.
six.
It is the respondent number 6 who is actually senior to respondent 5 in the petition.
No. But I am the second senior most.
You are the second senior most.
Is above D.
So you support the Mr. Nair.
Definitely fine, because our post has been sanctioned and it was allotted to the.
All right. Then Mr. Smith appears for respondent number 6 and adopts the arguments of Mr. Nair. So he submits that he is senior to the petitioner, and therefore petitioner has no claim for seniority. Where having heard learned counsels for the parties, this matter requires consideration in view of the interpretation of the various provisions of 2000 Act of 2017 read with the erstwhile Act of 2011. Let notice be issued returnable for which, since Mr. U. Sharma appears for respondent number 1 and 2, 1, 2, 3, and Mr. Nair, Mr. So-and-so Hazarika. As Hazarika appears for respondent number 5 and Mr. Kayum for respondent number 6. Notices of waived, however, extra copies will be furnished within a period of 1 week from today. Steps on respondent co by registered post within 1 week from today. Considering the submissions made by the learned counsels for the parties, the department will not proceed for regularization of the petitioner or the respondents on the basis of the judgment of the tribunal rendered on so-and-so date in so-and-so case until the next date fixed. Let the matter be listed again on 18th. 18th September.
I can fully take one observation because there is much being said. In the event there was no order of this honorable court in 1913, who would have been provincial? That's the department. Because of the interim order, their names were not put in the order. But otherwise it is they who were being provincial.
Fact is, it was not done.
Exactly.
It was done because of the orders of this honorable court.
Therefore,
Madam will have that instruction.
we are keeping the question open
Because
to
now
be
there is
decided.
a problem. If it goes in this line, neither of us will.
We can prepone the date if you want.
Lordship would do it.
Yes, my lord.
Lordship would do it. Because it's not going to help.
Tell us,
anyone.
give us a date.
Because Madam, I'll show the cash.
We will have it on 11th if you want.
Lordship, if
No,
2011.
not 11, my lord. 11 are delayed. It could be on 14th. my lord.
Lordship, my lord, if the 2011, my lord, the act is said to be not applicable. It will not be applicable in all three. That's the problem, man.
This is
There is
not
no
the
problem.
this is not the observation or the order. of this.
2011 act is not applied, there will be no problem for you. I'll still get.
All right, list of
Yes.
14th.
Yes.
14th.
Put it. My lord will also record that 2011 act is not being considered. That argument, my lord, will make a record. That he is saying that 2011 act is not applicable. My lord will be, that will be required.
So that means, my lord, that means it is the council submission is matters more than the judgment of the court.
The
And my
issue
lord, these are the people who are being elevated.
which are Mr. Chaudhary.
Oh, I'm sorry, man.
I don't think personal remarks are necessary.
No, my lord.
Please withdraw, no, Mr. Chaudhary, please withdraw the statement and
I'm withdrawing.
you'll tender an
I require
apology.
an apology, my lord.
You'll tender an
I'm withdrawing
apology.
this thing. I
to
require an
Mr.
apology. I am withdrawing this. This is against me, man. I'm sorry, man. This is the practice being over. Can't help it. I'm making a submission, my lord, on facts, not on anything else.
Yeah, correct. We'll ensure that Mr. Chaudhary will apologize in a befitting manner outside the court. Yeah, before 1:30.
I didn't want that.
The issues which are raised by the contesting parties is whether in the facts of the case, whether the provisions of the Act of 2011 or the provisions of the Act of 2017 are applicable, in as much as under 2011, the criteria for provincialization was on the basis of seniority under section 4,
Proviso to section 4(2).
proviso to section 4 within bracket 2. Whereas under the Act of 2017,
There is no such,
there is no such criteria prescribed.
everybody
May I please the lord say?
Yes.
My lord, in fact, I am the respondent, Lord, respondent number.
Who's for the petitioner? Petitioner is not here.
Petitioner is absent, my lord. He was there in the first term. Can it be after some time, some urgency may be on their part, my lord. In the meantime, my lord, I am required to file an affidavit, my lord. I have prepared the same, but could not file, my lord, after.
Pass the word of the day.
My lord.
We listed next week, Mr. Air for,
We are
Air for,
respondent 4, my lord.
respondent for, Mr. Chisti for, second grade.
Item number 19.
And appears passed over.
Item 20.
None appears for the petitioner one. It will know about it. About to time. Yes. Seba, who's for Seba? Seba was directed to file an affidavit. We'll give them some time.
Take minutes. Otherwise,
Heard Mr. A.I. Uddin, Learned Counsel to the petitioner by earlier order dated 6/6/2022. The SEBA, namely respondents number. Three, 4. Were directed to file the affidavit, which however has not been filed. None appears for the respondent Seba. Mr. Chisti appears for the secondary education department. List after 2 weeks, enabling the Seba to file the necessary affidavit as directed earlier by this court. The matter will be listed on 15th September.
21.
I'm sorry, my lord, I couldn't reach item 19, my lord.
Item 19.
Item 19 also not sure.
18, 19. Give.
Item number 18.
Yes. 18, yes.
On behalf of my lordship, in this case, lordship, the other side has to file their affidavit, lordship. Private respondent, yes, submitted, lordship.
Private respondent, yes, he was there. We'll pass it over for the day, let it come up next week. Let them file, yes. 19.
19.
May I please, your lords?
I know. This matter where I will our activity. I will. My. Learning pretty good. I will.
Have you received a copy?
Yes, my lord.
You filed a reply also?
There has been long time, my lord.
Oh.
Hearings have already been completed, my lord. The issue here is, my lord, pertains to whether an 18 months DLL course, the person having an 18 months DLL course is eligible for press recruitment or not. That is the issue here.
So this will require hearing, we'll fix it on, or we can, if the pleadings are completed, we can admit and fix for hearing.
My lord, for admission hearing.
For admission hearing. On 12th September.
Much of it.
Item number 21.
Affidavit by Mr. Chisti. File, not file,
No, not this fine.
not file.
Document can be damaged to time of this.
Further 2 weeks time is granted to Mr. Chisti, enabling him to file the affidavit as directed by this court. List on 15 September. Mr. Your name? Yes, Gautam appears for the petition.
Item 22.
Yes.
I know in this case regarding application for opening a pharmacy course in Department of Pharma courses watching by the Assam Science and Technology University. If the meaning that will be completed. So they start for.
Some counter affidavit is to be filed.
Worship everything filed worship,
No, the office note says so.
but counter affidavit worship filed by the is in the IA worship. They filed it.
Mr. Gogoi,
We have filed that in the IA.
in the IE.
The main case worship, I think not. Main case related to the university. And it is also the completed as a Simanta Shampata University lordship as a party. So may I start first with the litigation lordship. What I would like to say on the present litigation is concerned, main litigation. It has become infractions. Yeah, because of the notification annexed in the IE. Lordship mechanism is the prayer.
What is the IE?
Prayer made in the litigation.
Yes.
Place my case lordship. I pray lordship.
Yes, IE.
So lordship is the page 28 of the litigation. The prayer is to issue a rule calling upon the respondents to why the respondent number 2, that is the academic register Assam Science and Technology University Guwahati, they will not be directed to consider the application of the petitioner's institution and why the provisional affiliation of the petitioner follows in terms of the clause 3.3 of the UGC guideline as well as letter dated 22/4/2019 and satisfactory inspection report of the college shall not be considered. Now, during the pendency of this petition, it may now turn to the IE. The government of Assam issued one notification. The lordship will find that page 14. Lordship, page 14 is lordship. I am just pointing out to annex. Let me line my last time is supposed to reply lordship. I should have to place my page.
Page number 14.
14 of the IE. This is a notification issued by the Health and Family Welfare Department on 6/6/2023. By this notification, may I read it, madam? In order to bring uniformity in curriculum, infrastructure, teaching, clinical exposure and examination of pharmacy, nursing, physiotherapy, paramedical and all other allied health science education in the state of Assam, it has been felt necessary to streamline the institutes running these courses as there is wide variation in the admission procedure.
teaching standard and evaluation process of the courses. The government of Assam is pleased to notify the following. All institutions imparting education in pharmacy, nursing, physiotherapy, paramedicals, and other allied health services in the state of Assam, including institutions under other state and private universities, shall take affiliation from Srimanta Shankardev University of Health Sciences. The institute running the above courses under the affiliation of universities other than Srimanta Shankardev Health Sciences in the state of Assam, shall directly apply to SSUHS, that is the Srimanta Shankardev University of Health Sciences, for migration of their affiliation to SSUHS, and SSUHS shall grant affiliation to the applicant institutes after due examination from the academic session 23-24. The admission into these courses shall have to be made only through entrance examination conducted by SSUHS from the academic session 23-24. It may also come to notice that some private institutions are creating enervating havoc in the health education sector and doping the eligible students with a short degree diploma. Health Deputy Commissioner. Well, so as on date, my lord, the Assam.
They will now have to, according to this, they'll have to apply afresh.
Yes. Even when those who are already having the affiliation in other universities.
Here it is a case where they were not granted affiliation.
So now, my lord, if I have this IA, this particular notification has been sought to be challenged, my lord, which we must not, my lord, by a fair eye. We have to challenge it independently.
I come, Lordship. While during the pendency, Lordship, after hearing the honorable board, after hearing both sides, Lordship, there was an order for instruction about the status of that position. In the meantime, they passed the order, Lordship. And this order, Lordship, my application is pending since 1919, Lordship.
Before,
Before the honorable, Justice, yeah.
your what application?
For the Lordship, Assam Science and Technology, Assam Science and Technology University.
What application?
Lordship, my application was for affiliation. Pending, I deposited my fees. Lordship,
You applied originally before the Pharmacy Council.
Pharmacy Council given approval after 2024. And then for affiliation, for examining, being an examining authority, Lordship, the petitioner applied for affiliation before the Assam Science and Technology University. In the meantime, Lordship, they come to Assam, file their affidavit, saying that the government is withdrawing their power. In the meantime, Assam Science and Technology University granted approval, affiliation to the other institution, even in 2023. And why the matter was heard by the Honorable Court, Court number 2, in that day, Lordship, after hearing both sides, this court was asked for about the position of the Assam Science and Technology University and Srimanta Shankardev University. And in the meantime, Lordship, they come with this notification, which is completely violation of Article, Lordship. It is a purely Pharmacy Council of India, is purely a statutory body, Lordship. The state have no power to pass such type of order, and it is the continuity of that order. Accordingly, I file my additional affidavit denying this, challenging that same also in the repetition. My affidavit is also there, and apart from that, I also file a separate miscellaneous application. So my respectful submission, since it is a continuity of process of my application pending before the Assam Science and Technology University, now they are shifting for 2023-24. And my application, with all respect, Lordship, pending before them in page, Lordship, my application is page 6, 4 June, page 35. Just I'm giving the background of this case, Lordship, because we cannot get infractions with all respect, Lordship, on merit, Lordship. I want to get some relief on that because this petitioner is suffering since 2019. They have given the application, they have taken my fees, Lordship, and now all of a sudden, government of Assam come with this notification, and by virtue of that notification, which is completely a violation of Article 14, Lordship, because it is a Pharmacy Council of India is an independent body of the centrally sponsored, Lordship scheme. Under the fact, PCI has given the approval.
Page 35.
Lordship.
You sought for an NOC.
Lordship, for my application is for
D Pharma, diploma in pharmacy, which NOC of the state government is not required.
But nevertheless, you submitted.
Lordship. No,
Not given by the state government, that's the issue you were
Hmm?
NOC was to be given by the state government. Once NOC is given to university, then university can affiliate.
Lordship for
That NOC was
my-
not there, therefore we could not.
my resolution submission page 33,
And now.
Lordship for D Pharma.
Notification has come, your lordship. Ultimately, you have to challenge them.
Lordship, that notification, Lordship, is the continue. I have challenged Lordship. I should try to satisfy your Lordship on that point. Lordship, the paragraph 33 rightly pointed out, the above exclude subject to the submission of the consent of regulation of the examining authority for starting of the above course. No NOC is required for D Pharma course. My application is respect to submission for prayer for D Pharma course for affiliation. Lordship, accordingly, they have given a consent.
Where is the provision to say that no NOC required for D Pharma?
Lordship, page 33, Lordship. Regarding D Pharma course, it was further decided, may I read, Lordship? The above approval is subject to the submission of the consent of regulation of the examining authority for starting the above pharmacy course before making admission. But the B Pharma course, Lordship, then in next point, regarding B Pharma course, it was further decided that the above approval is subject to the submission of the consent of regulation of the examining authority and NOC of the approval of the state government.
Who is the examining authority?
Examining authority, in my case, Lordship, Assam Science and Technology University, where my application is pending before them. I deposited 1 lakh fees before them, Lordship. They allowed some other institution, I will come in, Lordship, I will coming one by one. Some of the institution even given affiliation in 2023. But my case, there is some objection, the state government NOC is required, which is not at all required for D Pharma diploma in pharmacy course, Lordship. Then, Lordship, my
Who's for the pharmacy council?
pharmacy council.
What do you say?
In their affidavit also there.
We have filed our affidavit manner. In the affidavit, it is clearly we have stated that manner. We are the expecting authority manner. But before the admission of the students manner, he will have to take the affiliation from the concerned examination authority.
Who is that?
They are the Science and Technology University or any other manner. Not now. Not now, but.
You are for S2. So your power has been withdrawn, now given to Sankote. So is there any application so far as the petitioner is concerned pending before S2?
Not finish it.
Lordship, page 68, my case.
We have not still done the application. There is the requirement of putting NOC.
By,
State government. State government has not issued their NOC.
so what has happened to that application? Rejected?
NOC of the state government has been, is pending since NOC has not been.
So now even if the NOC is given,
Cannot.
you cannot give. So you transfer this before the concerned university, who has the power to do so. You do it, let them consider.
Lordship, before that, Lordship, I am coming, Lordship, on that. Page 68, they have taken my case. Assam Science and Technology University. Then-
See, even if we accept your contention that they had the power,
Yes.
we are passing the order today when they don't have the power in view of this notification.
That is also I am challenging that.
No, that notification, if you have to challenge, then
I am also in IA application, Lordship, because it is a continuity of process, Lordship have every power, Lordship, to hold my relief, Lordship of that. I file my additional affidavit. Also, an additional affidavit stating that this is unconstitutional, Lordship. I am relying on some judgment which was happened in Uttar Pradesh also like that in UP. Some of the judgment, Lordship, the Honorable Allahabad High Court, thereafter Supreme Honorable Affairs Court, very recently set aside such type of notification because the state have no such power to interfere with the pharmacy council, which is a complete violation of state list, text 66 and concurrent list. Lordship, because it is a central subject, Lordship, pharmacy council is a central act, Lordship. The state have no power to control over the education and other purposes, Lordship, which I categorically stated in my IA application. So my resolution submission, that even then, Lordship, it was for 2023 and 24, next session. And the Assam Science and Technology University granted approval, Lordship, page, I'm referring
You're
your page.
challenging this notification for on what ground?
Lordship, because it is
This notification is exclusively of the state
Lordship,
to decide which university will have the power
Lordship,
for giving you the NOC.
Lordship.
Now, earlier it was one university, now it is the second university.
But
How are you affected by this?
Lordship, that is.
Your hurdle, according to you, is created by the state government by not issuing the NOC.
NOC. That NOC, Lordship, if I go there, Lordship, that point may be clear, Lordship, because the diploma in pharmacy course, no NOC is required.
Don't confuse the whole
And
issue.
apart from that,
We are now dealing with the IA.
IA, Lordship.
You say this IA, you are challenging the
Yes,
notification.
Lordship.
For what purpose? And how are you concerned?
Lordship, just.
How does it affect your right when the powers are transferred from one university to another? How does it affect you?
Lordship, because already Pharmacy Council of India has approved on the name of the Assam Science and Technology University, Lordship. They have approved also, and it is for 2000.
Then you want a direction from the court
Lordship,
to hold that since your approval was already granted,
Lordship, by the Lordship,
the new university should accept it.
Lordship.
But this notification is a notification to change the university
Lordship,
from one university to another.
Lordship.
How does it affect you?
That also affect Lordship. May I read Lordship, first paragraph, Lordship.
Hmm.
In order to bring uniformity in curriculum, infrastructure, teaching, clinical exposure, examination of pharmacy, all are guided by the Pharmacy Council of India, not by the state.
So you put it to challenge in a proper manner.
Lordship,
Then the contesting parties will have to respond to this. That this notification is in violation of the requirements of the provisions of the Pharmacy Council Act.
Lordship,
That the Pharmacy Council Act is a central act and in its domain, the state has no power to pass notification.
Lordship.
Can it be challenged like this by way of an IA?
Because it is I, without respect, Lordship, since my pendency of my repetition,
Maybe.
that point came, Lordship. And apart from that, Lordship, just.
We have tried to explain you whether you want an order from this court, we can pass an order right.
Lordship, just I am referring, Lordship, because in 2023, Lordship.
We are not denying the fact that you can challenge a connected issue by way of an IA or even by an additional affidavit. The issue is, you are now questioning the power of the state government to issue this notification, which was never an issue in the earlier petition.
Lordship. But that issue, Lordship.
Your issue is whether the state government's NOC is necessary in view of the provisions of the
Lordship.
Pharmacy Council.
That part will my.
That part we will decide.
Lordship.
But this IA in its present form, if you want to press it, then we are required to pass some order. Or if you want to independently maintain a challenge, it is your call.
Lordship. That, with all the state, Lordship, regarding the IA part, Lordship, before that, Lordship, the petition regarding the NOC, that part may kindly consider, and I think some instruction on my petition, Lordship, I will go for fresh petition on that.
No, we'll take it up together. Either you decide the matter now or it gets deferred.
But one thing is, Lordship, with all respect, Lordship, one submission is there. Others were granted approval.
We'll have to pass some order in the IA because once we decide the writ petition,
Lordship.
we'll also have to decide the IA.
Lordship. In the IA, Lordship, I pray for one time. But in the repetition, Lordship, regarding my application, it is pending. NOC part, that part, I pray, Lordship, may kindly.
We have tried to explain to you, if you do not want to understand and follow the procedure, we can't help it. Third learned counsel for the parties, the IA has been filed by the petitioner. Mr. Mazumdar takes leave of the court to obtain complete his instructions and prays for how much time you want?
Lordship. 3 days time, Lordship, next week, Monday, any day.
Week's time. where a matter be posted again after 1 week. Enabling Mr. Mazumdar to place the relevant. Enabling Mr. Mazumdar to address report on the IA as well as on the repetition. The matter needs to be heard. Why in admission hearing? We
Lordship,
should-
because if the hearing lordship, it may be in any day because the initial part it can be finished up because of which lordship repeatedly it was heard by your court number 2 lordship.
Then it was not parted, I believe.
Actually,
It was not parted.
because of which lordship I approved the court lordship for taking the part. Anyway, any court, I have no objection lordship, it may be hard. Next week, anything date lordship will I pray lordship. I will address in the repetition, maybe I will of the mistake lordship. Because my application, my fees, everything is pending before the ASC. And it is for the 2023-24 session, this notification. But my earlier part lordship, others were given in 2023, I have annexed this. in my-
Others may have been wrongly given. Do you want an order from the court? Then
I am not, it is very recently came lordship.
it is, you see, your primary challenge is that the state has no role to play.
Lordship.
Now you say that others have been given the NOC.
My assist.
Then you are abandoning your challenge. Then you are abandoning your challenge that the state has no role to play.
I am submitting on that line because they are saying that the state has stopped. In spite of having 2021, they have given in 2023. Why not my case? Lordship? But that part I.
Then we can close this matter, direct the authority to consider your case and pass appropriate orders. You are making contrary submissions.
Lordship.
On one hand, you are saying that the state has no power in view of Pharmacy Council Act. On the other hand, you are saying that no, others have been given, so therefore consider my case, which means you have abandoning the earlier such challenge.
No, there were the main case of the ASC lordship.
List after 1 week.
A statement kindly given lordship.
No, noted. You make a mention when you are ready to argue the matter. You get your instruction after 1 week.
Item 23.
Yes.
Item pertaining to application of my services by. My lord would kindly come to stage 63 of the repetition bylaw. Termination of 62 miles. The effective portion, my lord would find is page 63.
Yes.
63, my lord, upper primary school teachers, three Toshan period. I am Toshan period. I was terminated from my service on account of the fact that my name was not there in the DL. My lord. Whereas, my lord, there was a list which was floated, my lord, by the department. If my lord comes to page 33, my lord, there is a list of
Take my notes.
my lord, take my lord.
Where is the DLC my notes?
My lord, the DLP minute, my lord, I would find in stage. Running page, my lord. 69, my lord. Of the affidavit of opposition. That is my lord. Okay.
Yes.
My lord,
Where is your name?
my name is not there, unfortunately.
Hmm?
My lord, but my name reflects in the SLC, which is this DLP, my.
Kindly read the letter at page 62.
My lord.
The very ground of your termination is that your names were not recommended by the DLC.
My lord. My lord.
Do you want to file a reply?
My lord, I want to file a reply, my lord, because my name.
With the request of Mr. Learned Counsel for the petitioner. Matter stands adjourned for 3 weeks, enabling him to file a reply to the affidavit filed with respondent number 6. List after 3 weeks.
I you agree?
24.
When? What is this matter about?
Case relating to termination of service, the petitioner gave a grateful employee After 33 years of his start.
He has some difficulty, we pass it over for the next week.
Fixing a date was in. Inside a plan.
Matter will be listed again on 23rd. 23rd.
28.
21st,
21, 20,
25th. 25th. As it is submitted by Mr. So-and-so, learned counsel appearing for the standing grounds of Guwahati University. List on so-and-so date accordingly. 25th.
Item number 25.
Thank you very much.
Yes.
This case is relating to selection and appointment of principal for for Balaya Higher Secondary School. Here might not be petition earlier also approached this court and this court by law, the judgment is that face the case. And event arise this 32. Earlier also said beside them. This 32. Second paragraph, it is therefore necessary that the post of principal of the school, which had fallen vacant following superannuation of so-and-so, is required to fill up following a fresh selection process. As per number 5, who was appointed as principal of the school on an erroneous understanding of the legal position, may be continued for the principal of the temporary visit during the council, and the appointment is made following fresh selection. Certainly, he said, that's selection process. Second time, madam, they have advertised the post, my lord. That is at page 35. Page 35, connection 9, my lord. This is also not as per rule, my lord. And aspirant research of Kolaiga, last paragraph I'm reading. So aspirant research of Kolaiga Higher School are hereby informed to apply relevant documents for the post of principal of Kolaiga Higher School to the undersigned on or before so and so. All the particulars should be of this public is self-addressed. So as per rule, my lord, 2018 rule, it has to at least two, newspapers, they have to widely publish. Otherwise, my lord. Yeah, my lord. The education department also filed to a visit, government also filed to a visit. And my lord. I am selecting second position, in the first position. The number also given, my lord, not according to the rules. And there advertisement goes. Then my lord, you have to re-advertise and my lord.
Yes.
Yeah, the 2018 rules for Assam Secondary Education Provincial School. 2018.
Where is the earlier order?
Earlier order at page 28 it starts. Page 30. Page 28, the next section. We have also private respondent. His appointment was cancelled. We have now the principal itself.
This was filed by whom? By you.
By me, my lord, I am in the second position.
Earlier writ petition,
Earlier petition also filed by me.
you challenged the appointment of number 5.
Yes, sir. Private respondent.
Hmm.
Here also, my lord, the advertisement at page 35. The IC principal has advertised, as per rule, the inspector have to advertise that was.
This order was not appealed against.
No, no.
Then what happened after that?
By himself, by the private respondent at this 35, he himself advertised the post, my lord. Principal insists following up I say this good, this 35.
No, pursuant to the direction of the court at page 32,
Yes, my
what happened?
advertisement. Pursuant to the order, my lord, page 32. This one of I mentioned on the plaintiff's mention, temporary reason for regular appointment made on a press selection. Certainly, submit a petitioner who will be the petitioner. A press selection is, let the press selection be conducted within a period of 4 months from the date of receipt of the subject of
All right,
the
then,
Then why not, instead of advertising the post by the inspector, page 35, the respondent, private respondent, who is working as inside principal, he advertised the post and within the school only. Although I also participate, my lord. We realize that, my lord, that
you also work in the same school,
I am also working the same school and my position is the second position.
and number 5 is number 1. Respondent number 5 is senior.
My lord senior, and my lord, according to March, my lord, it's a advertisement is made kind of according to the guideline of the March, my lord, at page 19. Office memorandum, revised guidelines for selection of principal of provincial and higher secondary school. So awarding marks also, my lord, has been defective.
So where is the final order which was passed?
So the interim order is at my lord. The interim order
Page 50.
is 50. Page 50, my lord, is the interim order.
And this order you have challenged now.
Yes,
Hmm.
this appointment I have challenged. I challenge, my lord, because, my lord, I am in second position. If his, my lord, not entitled or not according to the, my lord, guideline of the his mark was given, not as per the guidelines of the, my lord, education department. So, my lord, I have challenged. But I have realized, my lord, the advertisement itself is, my lord, wrong. So, my lord, it was has to re-advertise and again there is the enter for selection. Because, my lord, as per rule 12.4.3, the inspector of schools shall invite applications from the intending eligible candidates through an advertisement to be published at least into widely circulated local newspapers, including school notice boards. I am submitting one of the advertisement which I am so, one of the also, otherwise, one of the action has, he has been given marks illegal. Not as per the guidelines of the,
Where are the marks he is obtained?
it is in page 49, my lord.
49. So what is the illegality here?
Illegality, my lord, experience marks, he has given 4. Actually, he is not entitled for that marks. Because he was, after the inside principal, he has not completed 1 year.
Your name has not been considered.
My name is at my lord, third position.
Or
Is department of the first seniority and third position, but my marks is at my lord 17. His mark is also 17.
7 or 17?
17, my lord. She. Serial number 3. Clause.
No, number 1,
Number 1, my lord, typing mistake, my lord. No.
it should be 17.
17.
All right.
So if his experience mark goes, then I am entitled to be appointed.
Yes.
That I have written here, my lord.
Who's
He has
for
not
the-
completed
Who's for the state?
1942.
Who allows this mark?
Committee, selection committee.
Selection committee under the rules is to be constituted by the state.
Yes, ma'am.
This is the school selection committee.
But my lord, school selection committee means, my lord, others are there, my lord, because the inspector advertised. Here, my lord, the principal advertised, there is a difference, my lord.
School selection committee on order to select and then sends it to BTC authority.
Under what provision? Show us the provision.
No, say,
The rule 18, they also follow rule 18, right? As some secondary. People also with the good pilot and they started sheet. Education of
Rule 18,
they started sheet.
yes.
32 and 30. Page 32 minus recruitment to principal and procedure there. And here is five.
You have five.
Four, two.
So after advertisement, it is to be considered by the district selection.
Yes, sir.
So what is the recommendation of the district selection?
That is the recommendation, madam.
Page number 49. Is this a page number 49? No.
49 is the election committee
Here, madam, page 47.
comparative statement of marks.
Page 47.
We have one effect your lordship since it is your
Selection
lordship.
committee report, madam. Page
It
47.
is your lordship. Therefore, if your lordship,
There is no district.
therefore your lordship is the principal secretary, board and territorial council. Then your lordship director education. These are the authorities. Rules.
Seven months.
So this is the state level.
Yes, madam, 47.
What about the district level?
Here, madam, the state level, madam. State level means, madam, their district. Here, madam, minutes of the BTC level selection committee. BTC level selection committee for promotion of the post of principal in senior secondary and higher secondary school
Okay.
under BTC.
Now, on what basis are given the marks of experience?
There is a guideline you know, by issued by state government.
Where is that guideline?
By
Page
some-
45.
They have a.
Page 45. 45, no, it is, I think, but page 42. madam. Page 42.
Yes.
Revised guidelines for selection of principal of provincial and higher secondary school awarding marks. Here, my lord, page 43, column 5 is experience marks. Experience in such principal. A, B, C, my lord, last column.
So maximum of 3 marks.
1 mark for each year of experience, subject to maximum 3 marks. IC principal should be authorized by DSA to hold the post. And here he has not completed even 1 year.
Assuming any marks are to be allotted, then it must be to a maximum of 3,
See,
not 4.
No, your lord, that is your lordship, 3 experience. And there are 3 columns, experience as graduate teacher, your lordship. Here you have 3 marks. Either as a graduate teacher or as a postgraduate teacher. You will get it, then your lordship, the experience in charge, this is another category.
So how is the marks being allotted?
Your lordship.
Break up of the marks.
Breakup, your lordship, I got in experience in third principal 1 and 3.
How do you know? How do you know?
That is her.
this 49. And.
Education, your lordship.
No, This 49.
So 49 is the final marks.
Yes.
I am asking you the breakup of the marks.
Your lordship,
It is in record only.
Use for the BTC. Any breakup?
There with her.
Page 49 is the marks allotted. Then page 43 is the guideline. Now, do you have any record as to how the marks were applied? Marks were given.
Sorry, I will explain my.
57. 57 is a part of the affidavit of private response.
87.
87. This is additional evidence. Yes, yes.
There are three losses.
There are three.
There are two. Because the 67 plus the one post when the proportion of the principal and under the selecting selected as fundamental by the only in of the holder as part of the minus of the selection of committee, they will for 2020. Accordingly, the secretary and supported the responsible number five, so they want to appoint the principal approval of the secretary. Right, letter number 7 against the waiting for the principal of the Palaiba Higher Secondary School, Vice Sri Divakar Gulkar Region. Which is mentioned as the responsible for 10 total mark 70 numbers in the interview carried on before 2020. However, address it, selection committee was given 4 marks extra for service experience to the respondent number 5 to the and 3 marks extra to the service experience in respect to the goal. As such, the respondent number 5 is was selected by the committee, making higher service experience as interest principal of Palaiba Scientific School. Then the petitioner described in policy number 1 in the constitution for the
So that 1 mark made all the difference. Now, according to the petitioner, that 1 mark is to be given only on completion of 1 year.
as inside.
As in charge. 1 mark for each year of experience. So according to the petitioner, he did not complete 1 year. What do your records say?
I have denied it.
When were you appointed as in charge?
Lordship, what has happened, your lordship here?
So as per the affidavit, the department has made a categorical averment that
I was, lordship, what has happened about this 1 mark, your lordship? I was appointed as your lordship principal, your lordship, on 31/1/2018.
principal or in charge.
First principal, regular principal, your lordship. Which was put to challenge, your lordship.
Then interfered.
Now, when I was put to challenge, that was put to challenge, if your lordship comes to the order passed by this honorable court, your lordship will find. And that was interfered, your lordship, on. Your lordship, the date is 12/3/2019. 12/3/2019. Now, in fact, in earlier selection process, I was in second place. The candidate, the number 1 of the
That select list, from the select list, the earlier incumbent was appointed.
appointed. They are
Then he
this-
superannuated.
Yes, sir.
So they filled it up by
From
the wait list.
Which
Wait
they
list.
should not have, since it is, that's what this honorable court has.
So from the time you were appointed
To
to the date of the order, what is the period?
that period, it will be around 1 year. Your lordship, 31/1/2018 to 12/3/2008, 12/3/2019. It will be 1 year and.
That is your interpretation. We wanted to find out from the PTC authorities.
Lordship, that is for the teacher authority, your lordship. But what I am saying, your lordship may kindly see the order. The order, it says
the last paragraph, it is therefore necessary that post of principal of the school which has following the exam following superannuation students is required to be filled up. Following a press selection process, respondent number 5, who was appointed as principal of the school on an erroneous understanding of the legal position, may be continued. So your worship, my submission will be, your worship, in view of this, or your worship, continuation of my earlier service. The entire period of experience I have gathered, your worship, during this period, your worship, that will your
Pursuant to this order,
worship,
was any other fresh
your
order
worship,
issued?
your worship, that is at page 33, your worship. We referring to this order, quoting the order passed by the Honorable Court, they allowed me to continue.
You were appointed on which date?
On your worship, 31/1/2018. Let them submit your worship, I will come. Submit.
Yeah, you have already submitted, so we are just getting the dates from you.
Yes, ma'am.
31/1/2018.
18. And the advertisement is your worship. Is dated 12/9/2019. Now, your worship, the experience I have gathered, your worship,
During the advertisement also, you were holding charts. And the final order was passed on. Sorry, the selection was made on.
your worship, that was
4/3/2020.
4/3.
4/3. So by this,
7 months. I am coming, madam. Page 34 and sir 8.
34.
Yes.
Lecture eight.
Selection to the ones. References of the cited above, I am to inform that Siddhartha Sawadya, existing principal of Kodagan Sanchalaya Jurisdiction has been reverted to his post of postgraduate teacher in the subject of political science. Higher order that so and so and quotes of the amendment and the post of principal in the school has fallen vacant. Inspector was insolvent. Therefore, you are requested to call the particular.
You are reading from which page?
Page 34, minor.
34.
You are reverted back on 4th September 2019.
On 19.
Yes. Now you are.
Now- He claims to have been appointed on 31/8/2018.
During the course of this board has set aside his appointment.
Yes,
Prior to that
but
period.
the court gave liberty to consider his post as, consider him as in charge principal.
On 12 March 2019, given judgment from the principalship removing him by his judgment. But they reverted back on 4th of September 2019. He has been reverted back in page 15, paragraph 17, you will also, and it's page 15, 600
Page 15.
15 on 5. Paragraph 17. That the petitioner makes to state that Siddhartha Sawadya is number 5 by judgment and order attachment was reverted to his original post, which was implemented by order effect 28/2019, file number 7. Thereafter, the post of principal was advertised on 12/9/2019. It is on 4th September was removed and 12 September the post was advertised. It is important to note that respondent file from taking over charge of principal to selection of principal till 4/3/2020 has completed 7 months only as in-charge principal. Whereas as per clause 5 of the government terms and so 1 year mandatory services necessary for granting additional mark during selection. As such, respondent 5 has not completed a period of 1 year mandatory service continuously as in-charge principal, hence he is not entitled to get 1 month in addition. So from my lord, September 12 to 4/3/2020. September to March, my lord, It is 7 months only.
After the coordinate bench's order holding that his selection is back, interfering. And he may be continued as in charge principal. Was there any order passed allowing him to continue as in charge principal?
Page 33. Page 33 order, last paragraph.
August, yes, 28 August 2019, he has been allowed, and by the 4th September 2019, has been ratified. Because my lord, the selection procedure are not in my lord,
So that
because if we hold the post, my lord, there will be, my lord, some complication, my lord. Director of Education, Guru and Territorial Council has passed.
Last paragraph, in view of the above, BTC is pleased to direct the Director of Education Assam post sales for press selection. To the post of principal with the Kolaigaon successful within 2 months from the today and further directed to continue the service of Sri Janka Sogore in the capacity as the in-charge principal of the sales school purely on temporary basis following reversion from the post of principal. Presently. That's a continuation of yours.
Yes, but again, they have subsequently passed the order.
so this order was passed on 28th August
August
19. And you were reverted back on
On that, 4th September order is also for collecting.
no, but you reverted.
No, I will have to listen, I am from regular principal to, I became your lordship, I have to go back to your lordship, get back to your lordship, the substantive post of postgraduate teacher. But while being in subjective postgraduate teacher, I also hold the post of in-charge principal.
How? By which order?
Lordship, this order, I have not been reverted again, separately, but position has not been taken over from me, of in-charge principal. I continue.
No, you're right. You see, the coordinate bench by order dated 12/3 has held that your selection to the post of principal is back.
There,
So the authorities were directed to
all fresh.
all fresh. So your that order by which you were appointed goes
That goes.
on 12/3/2019. Liberty was granted to permit you to continue as an in charge.
And they.
But by this order of the court, you were not directed to be. You were not directed to hold charge as in charge.
Maybe continue, Your Worship.
No. He, respondent 5 was appointed as so and so, maybe continued as in charge so and so
Principal of this.
till. So there has to be an order.
That is Your Worship at page 33. Last paragraph,
33.
last paragraph. In view of the above, may I read Your Worship? In view of the above, BTC is pleased to direct the Director of Education, BTC to press.
Very well. You
Then,
continue.
last line, Your Worship, the post of principal presently held by him to the post of subject teacher, and he will continue to so till fresh election to the post of principal.
Correct, but subsequently again on 4th you were reverted back.
Look, Your Worship, this is, there is, Your Worship, may I read the next letter, Your Worship, 4th September, what is the content of this letter? With reference to the subject cited above, I am to inform you that Sri Jayanta Sogore, existing principal of Kolaigaon HS School, under your jurisdiction has been reverted to his post of postgraduate teacher in the subject of post and by this office order number so and so dated 4th September 2019.
Where is that order?
That order they have not annexed.
That order is 1 day prior,
Lordship.
not 1 day,
Same day.
same day, but
Same day.
one different order.
Lordship. Therefore, you are requested to call for the particulars of eligible candidate from the school and submit the same in prescribed format to this office within so and so. Now, Your Worship, ultimately, I will have to be reverted back to the post of subject teacher. Since I am holding the substantive post of principal, if done, I will be reverted back to the substantive post and
You are already reverted by virtue of this order,
Lordship.
12-3.
Lordship.
12-3 when it sets aside,
Lordship.
leaving effect is you are reverted back to your post.
Lordship. But continued as IC principal.
No, so this continuation, we'd like to go through this order of 2021, 2018-15, issued on 4th of September.
That Your Worship will be.
Is it available? Come to page number 34, please. Come to page number 34 of the writ petition.
No, 34 of the. 16, 15.
The post of principal is a direct recruitment. If somebody is already holding the post, there are some difficulties.
In charge.
In charge. But
Somebody will have to be, somebody will have to run the office of a principal, either,
Inspector
from
of
the
schools
school.
normally run, inspector.
but in your case, it is the petitioner who was permitted by the single judge also. You have the copy of that order. Kindly come to page number 34. In this letter, you find a reference to another order issued on the same day.
Same letter. Memo number 19, memo number
16 is not there, 15 is not there, 16 is.
Some order was passed reverting you.
Lordship.
Some reference could be there.
16 is there, Your Lordship, but 15 is not there.
But this letter 16 itself says there is an order.
That will be required. That will bring space.
Is there any other file? Third learned counsels for the parties. This petition is filed by the petitioner, challenging the selection and appointments. You are appointed now. Selection and appointment of the private respondent as the principal of Kolaigaon Higher Secondary School under Udalguri district. So the private respondent was earlier shortlisted during the process of selection to the post of regular principal. It is principal or headmaster? Principal. In the select list, in which during the process of selection, the respondent number 5 was listed serial number 2. Thereafter, the incumbent at serial number 1, Sri Divakar Bushok, who was appointed as the principal of the state school from the state select list, superannuated on 31/1/2018. So, upon superannuation, prior to superannuation, on the eve of superannuation, by order dated 19/1/2018, the Director of Education BTC appointed the private respondent number 5 as the principal of the state school. So this was challenged by the present petitioner before this court in WPC number 2021. Stop this court by order dated 12/3/2019. Interfered with the selection and appointment of the private respondent, who was also arrayed as respondent number 5 in the said petition. Stop. The coordinate bench arrived at a finding that since the select list was for appointment to the post advertised, and from the said select list, the person at serial number 1 was already appointed, the select list had spent its force, and therefore further appointment from the said select list is contrary to law. Stop. The vacant post was directed to be advertised, and both the petitioner as well as the private respondent were permitted to participate in the same select list. So the coordinate bench, however, permitted the private respondent to continue as the in charge principal of the said school on temporary basis till regular appointment is made following the selection. Pursuant thereto, the PTC by order dated 28 August 2019 directed the services of Sri Jayanto, the private respondent, to be continued in the capacity of in charge principal of the said school. Stop. Thereafter, the process of selection for the post of principal was undertaken, and both the petitioner as well as the private respondent appeared for selection process. Pursuant thereto, by selection minutes held on selection minutes of the BTC level selection committee dated 4th of March 2020. The respondent number 5 was held to be the shortlisted candidate. Stop. But thereafter, by order dated 26th of February 2021, the private respondent was appointed as the principal of Polaigaon Higher Secondary School, Polaigaon. So, being aggrieved, the present writ petition has been filed, putting to challenge the selection and appointment of the petitioner, respondent number 5 as the principal of so-and-so school, as well as playing for setting aside and quashing the PTC level selection committee meeting / minutes held on 03/2020, along with the appointment order dated 26/2/2021. So there are pursuant to issuance of notice, the parties, contesting parties have filed their pleadings. The counsel for the petitioner submits that the selection of the petitioner is contrary to the provisions of the Assam Secondary Education within bracket Provincialized Schools bracket those rules 2018 on 2 counts, namely, number 1, that the advertisement was required to be issued by the inspector under the rules, whereas in the present case, the advertisement was issued by the principal in charge principal of Kolaigaon Higher Secondary School, who is the respondent number 5, and who himself was a candidate. Stop. That apart, there is a set of guidelines issued by the commissioner to the secretary, commissioner and secretary to the Government of Assam Department of Secondary Education by notification number date, so and so dated 26th of December 2018, page number 42. Wherein the experience under the column experience, the marks to be allotted for experience as in charge principal are as under. Extract that experience as in charge principal and the marks, page 43. Learned counsel for the petitioner submits that the marks allotted through the petitioner as well as to the respondent number 5 in respect of experience are 4 and 3 respectively. Sorry, 3 and 4 respectively. It is submitted that one additional mark allotted to the petitioner, allotted to the respondent number 5 on account of his experience as in charge principal is contrary to the guidelines, as we say, experience falls below the requirement of 1 year as specified in the guidelines. Stop. Consequently, that extra mark would not have been awarded to the respondent number 5. Stop. If that extra mark was not awarded, then the then the petitioner would have scored. But both of you would have been scoring the same marks.
No, my lord, I would have been, my lord, 17, you would have been 16.
Would have scored, would have been the selected candidate. Stop. Learned counsel appearing for the PTC submits that the affidavit has been filed, and referring to the affidavit, it is submitted that the selection process has been conducted as per the provisions of the Act, and the marks have also been awarded as per the provisions of the Act and with the guidelines. So it is submitted that since the petitioner was allowed to continue as in charge principal, that extra mark, 1 mark was allotted. Stop. Mr. Bothakur, learned counsel appearing for the respondent number 5, submits that he was allowed to continue as the in charge headmaster, in charge principal, and this is apparent. This is apparent upon the bare perusal of the order dated 12/3/2019 passed in WPC to 2021 of 2018. Learned counsel for the respondent number 5 submits that his experience as in charge headmaster with effect from the date of him being appointed as the principal. So in charge principal, with effect from the date of him being appointed as a principal, if taken into account, will be as per the requirement prescribed under the notification, and thereby he completes more than 1 year. More than 1 year, and therefore is entitled to the extra mark allotted to him. Stop.
For September, data may not be divided by. Inspector. For September.
Petitioner submission, you add one line. Learned counsel for the petitioner submits that the petitioner is respondent 5 is not entitled to get extra 1 mark in view of the order dated where is that order? In view of the order 4th of September 2019, whereby the petitioner was reverted back to his post of postgraduate teacher in the subject of pole science. ID office order number so and so dated 2021/2018/15 dated 4th of September 2019. So in order to decide whether the petitioner whether the respondent number 5 satisfies the requirement as prescribed under the office memorandum dated 26 December 2018 regarding the requirement regarding the specification as per specification for experience as in charge principal for 1. It is relevant to refer to the office order number so and so dated 2021/2018/15 dated 4th of September 2019, which according to the PTC authorities, the respondent 5 is reverted back to the post of postgraduate teacher in the subject of pole science. So although the PTC authorities have filed their affidavits, that letter is not enclosed to any of the affidavits filed. So MSRB Bora, Learned Study Council BTC is in possession of the relevant records, and upon due perusal has submitted that the same letter is not available on the records as on date. Is it not available here or is it not available at all? The BTC authorities, since this letter by the office number so and so dated so and so 4th of September 2019, by which the petitioner was reverted back to the post of postgraduate teacher in the subject of pole science, is considered relevant for the purposes of counting whether the petitioner meets the criteria as prescribed under the OM dated 26 December 2019 for experience as in charge principal. 1. The PTC authorities will produce the same communication and any other connected communication before this court by the next date fixed. You tell us when you can produce it. 2 weeks. Why 2 weeks? Only one letter. It is there or not there? You can do it tomorrow. List on 22nd, enabling the learner PTC council to produce the said letter. Upon such instructions being placed before the court will proceed to hear the matter.
Anything on 24th?
Item number 26.
And please, potential mobilization of services. Initially,
Available, awaited.
which is if you come to page 35, initially, 35 logic. Initially, logic, this petition was filed by 14 adult also. So an order was passed to file different petition for all the petitioners. Since right to commercialization of regulation is an addition and lordship.
Let them get their instructions. Is awaiting her instructions.
Same letter was disposed of few days back to file an appeal before the order date. What if that order can be passed?
Do you have a copy of that order?
Not sure, I don't have the copy of the order, but
All right,
similar matter also I have.
under section, rule 4, rule 14. What do you say, madam? All right, had disposed, appeal to be preferred under section 14 of so and so rules. Within a period of 2 weeks from the date of receipt of such event. Thereafter, appeal to be decided within a period of 90 days from the date of filing the appeal. Any order passed shall be served on the writ petitioner. Similar orders we have passed to check up. Rule 14 of the so and so rules disposal. Yes.
Item number 27.
Instructions.
Here I'm again for the finance department, actually we were directed to file an affidavit matters. Here, but we have raised certain.
Sometimes it is better to look around. There is nobody else.
Yes, sir.
Fast forward. Next week.
28.
Mr. H. only address for finance.
Here, if the continuous file their affidavit in opposition, we have also filed a reply.
Admit for hearing.
Maybe doing like this, please petitioners are.
This is 22 matter.
No, they
You can
can
admit for hearing.
no, say, these petitioners here, no, say, can intending candidates for the upper primary teachers. post.
Any interim order.
No interim order.
So we better to hear it.
No, see, it will be hard in the admission column. That's my prayer. Advertisement.
At the request of the councils to the parties matter is to be posted for admission hearing on 19th September. Learned Council, Mr. Bottakuri appears for petitioner and is seeking for respondents. Sutia, yes, sorry.
Item 29.
Here in this case, I am for the private respondent. Now, government has filed an affidavit. It is not hard to leave. I am
Yes,
also
government who is
respondent.
appearing for government.
So government is also respondent, but I want one copy. I want one copy, madam.
Mr. Council for the government, give him a copy. Mr. Goswami, you received copies? Are you file your reply also?
Reply yet to file.
You want to file? Mr. U.K. Goswami, Learned Council for the petitioner submits, he requires a short date to file. Reply to the counter affidavit filed with the petitioner. Prayer is not objected to by the Learned Councils for the respondents. Mr. M.A. Sheikh, Learned Council for the respondent, 5. Submits that copy of the affidavit in opposition filed by the government is yet to be served. The government council, Mr. Sharma.
Yes.
You have an extra copy now? Now?
Yes, ma'am.
Has undertaken, has already served a copy of the affidavit filed with the government in court. Accordingly, matter will be listed after 3 weeks. 3 weeks. Is there any interim order?
No.
Yeah, what?
There also order was to continue.
It has not been extended. It has not been extended.
So why not let it remain as it is?
It
has not been extended.
Order was initially provided, accordingly, I am moving to both of that.
Interim order passed on 21/9/2022 will continue till the next date of listing.
Hello.
Let it be listed on 21st of September.
Item number 30.
This method is covered by the judgment of the court verdict, but for regarding the rejection of 3 years remaining term measure of the compulsory.
What is the status of the appeal? It is submitted by both councils that this matter stands covered by a judgment of the coordinate bench passed in
My lord, WBC 1646 of 2021.
1646 of 2021 and other connected writ petitions. Within bracket Bhaskar
Poor.
Kumar.
Yes. Absolutely.
List again on. Oh, sorry, we are disposing it of. It stands covered, matter accordingly stands disposed of. In terms of the pursuance of direction. Yes.
Item 31.
Last time, you have to matter for some time, the investigations of the 2 issues, my lord. So there is no allegation at all. The main allegation is against the general secretary only. Without following the mission and procedure and without any proceeding having been initiated against them. One of the 2 issues of petition to investigated on file.
Who's for the respondents?
On the other side, last time was the last 2 was making the
The illegal matter already is
You are agreed by what order?
order matter, the include order. There are two orders matter, and it's a key, the 23 and the next one 24. There is 1/7/22 and last year's that we issued their investigation order. No inquiry is conducted. No person hearing, nothing.
23.
Yes. And they last time they also ordered them to, on what rules or regulation they have told me. Secretary, they could not reply anything. They took time.
All right, at least next week, enabling
Telling you next Tuesday, when we meet other matter.
21st. 22nd. 22nd.
20.
Matter will be listed on 22nd for admission hearing. Mr. R. Sharma appears before the hearing or assisted by Ms. Swin. Mr. A. Ahmed for Guwahati University, Mr. Tovildar for CCC. Higher education, higher education.
And the other side is.
Who is the other side?
From the
College authority.
college of.
It's there for. None appears for the college authorities.
Item number 32.
Maybe the last of the number responding for timely filed their affidavit.
It's not. Challenge the case lecturer.
Instruction not to file affidavit.
I think it can be disposed of in my oral instruction also.
Ah.
The fact of the case is that it is not appear for case lecturer. It's even the process, the entire process. After receiving the notice, the entire process was cancelled. First selection was held. A new incumbent has been appointed. This is the case from Canada. Yes, lecturer. In different streams of the.
Why was it cancelled?
Also because the challenge and after receiving the notice, the entire process of cancelled.
And you have made his petition infructuous. Then we'll have to take judicial notice of the subsequent process which you have cancelled, which you have held.
Because also there was no stay.
May not be. When somebody has come before the court, you have cancelled it.
I produced the record. How many weeks time? So,
Mr. SCKL Learned Council appearing for the university, Assam University, submits that the relevant reports will be produced before the court on the next date fixed. He submits that the earlier process for selection of
guest lecture.
guest lecturer has been cancelled and a fresh selection has been initiated by which a new incumbent has already been selected. Mr. Hazarika, Learned Counsel for the petitioner, appears for the petitioner. You are not challenging the.
No, well, as per my instruction, my lord, it was extended, not as advertisement was issued. I have to challenge it.
All right, let him produce. Who are the private respondents?
6 and 7, they are not in South.
Respond number 8 and 9. So as per Lozima, report number it was respond number 8.
Complete. Yes,
Okay.
list after 2 weeks.
Okay. Okay.
Item number 33.
Very good. I mean, I have a very good comment about 1 and 2. Simply we have filed an additional application. It is not on record. The affidavit may be gotten record and it may be taken out.
Mr. Parwari, Learned Counsel submits that he has entered appearance on behalf of
Record number 1 and 2.
1 and 2. And he has filed an additional affidavit, which however is not connected to the case records. Mr. Gautam, S. Gautam, Learned Counsel appears for the petitioner. You have received a copy?
Yes, sir.
As the said additional affidavit stated to have been filed is not connected to the case report, matter is deferred for a week. For 2 weeks. Stop registry to verify and trace out the additional affidavit stated to have been filed by respondent 2 and 3. Two. And connected to the case record. Let the matter be listed after 2 weeks. Status quo order. Passed earlier on 22/12/2022. Shall remain in force. Till the next date fixed, based on 15th September.
Item 36.
May I please your question? In this case, petitioner was appointed as science teacher in the Radipur A Madrasa. He joined the service on 30/10/2005. 36.
Waiting for
Notice was issued on 29/5/2020.
It is submitted by Mr. Pegu, G. Pegu, okay? Learned Study Council, Elementary Education. That instructions are still awaited, he prays for 2 weeks time. You are for elementary education. Mr. F.U. Borguia appears for the petitioner. Let the matter be listed after 3 weeks.
Which similarly situated person got benefit. I am the only science teacher by implementing order. Earlier, I approached the court. This court directed the office to pass a review
2
order.
weeks, list after 2 weeks.
37.
Fixing a date.
After,
Item 37.
yes,
it is very urgent.
I have already sent affidavit for wedding mail.
huh?
The affidavit I have already sent for wedding mail. Sometime maybe given that you will
My lord,
This is the case here in this that student has become the security guard of the IIT hostels, my lord. And it is very otherwise serious case has been met out from the record and everything. That is the reason I've already sent the affidavit, my lord. Short time of 1 week or 10 days, my lord, will be granted to me. I'll file the affidavit. All things will come into picture.
my lord, one thing your lordship is going to.
What is the impugned order?
You don't order, my lord, your lordship.
Rusticated.
He had case 37, my.
He has been rusticated.
Yeah, first, I told him you are terminated. And secondly, you are suspended. Till June 2023. I am the student of PhD, man. And
No, where, what is the order passed?
that is at page 37, man.
Yes,
May I read it, my lord? It was passed. This is in connection with the.
his studentship has been terminated
Terminated.
with
Subsequently,
immediate.
I tried the appeal, my lord. Appeal was allowed, whereby only the suspension, my suspension was justified till June 2024. Apart from it, I have to pay 50,000 pesos. Fine, my, that you will to find that page 43. Page 43.
So your deposit of 50,000 has been stayed by the court.
Yes, my lord, that was the state.
Hmm.
My lord, now, since he is taking the time to find the evidence, 18 times the evidence, my lord, one time, 20 times, we kindly be allowed to him, subject to allowing me, modifying the earlier order, my lord, the order, allowing me to attend the classes.
No, my lord. That will amount to allowing the repetition.
My lord, subject to the outcome of this petition.
Your original termination order was modified, you are now suspended,
Suspect,
subject to payment of 50,000 or whatever.
yeah,
That has also has been stayed.
it stays only 50,000.
That's right. So you are now on the suspension
Suspect.
as a matter of interim measure, if we allow you. What remains to be decided in the writ petition?
Because at the very initial stage.
We direct him to file the affidavit within 1 week.
1 week, we do that.
Then we'll take up the matter.
Let it be last chance time.
Mr. A.B. Day, Learned Counsel for the IIT Guwahati, prays for a short date to file the affidavit in opposition. Mr. O.P. Bhatti, Learned Counsel, appearing for the petitioner, submits that since this is a matter pertaining to the academic career of the petitioner, no further time be enlarged, allowing him to file the affidavits. So considering the rival claims in the matter, this court is of the considered view that a week's time can be granted to the petitioner, to the respondent, to file the affidavit as prayed for. By the next date fixed, the IITG should file their affidavit.
Particular date may have.
Sorry,
Particular date may have.
yes, we are fixing a date. 15th September.
My lord, 4 weeks. My lord, very urgent one. What is the next week, man? 1 week time, he is taking only 1 week time.
Today is
16th.
28th,
Obliged, madam.
28th August.
If earlier, will be put.
If earlier, 1 week will expire
Nothing else.
on 24th.
Change on these things, madam.
1 week will expire on 24th. We are giving you 28th.
For daily, I think 38.
Second way,
Second way, madam, here starts in immediately.
you call for the scan copy.
Leading it.
When was the charge sheet submitted?
Starts in immediate on madam, 11/8. Leading it here, recorder. For regular.
He'll appear. All right, third Learned Counsel for the matters. This is the second bail petition filed by the petitioner. Again, apprehending arrest in connection with the FIR dated 7/1/2023 filed by the informant Stop. The petitioner had earlier approached this court by filing a petition number 385 of 2023, which was rejected by this court on 15/3/2023. So, pursuant to the second bail application has been filed by the petitioner. So, CD was called for. So, today when the matter is called up, Learned APP submits that charge sheet in the matter has been filed by the charge sheet number
166 of 23.
166 of 23 dated
11/8.
11/8/2023. Learned Counsel for the petitioner submits that the petitioner be permitted to appear before the court, competent court, before which the charge sheet has been filed. Accordingly, the AV petition stands closed, permitting the petitioner to appear before the competent court and file bail applications. So, while considering the bail application as may be filed, the competent court will take note of, will decide the matter in its own merit, and also take note of the law laid down by the apex court in Siddharth and so and so in other cases. Bail application stands disposed of in Learned Counsel.
For orders, item number 39.
Nothing. Petitioner has already been, his passion has been regularized, but that was the direction we found so that he's getting the regular pension.
Proper pension is not given, my lord, that's it, my instruction. Your lordship would be pleased to see the office note dated 19/6/2022.
First, let us see the order, direction of the court.
Yes, ma'am. Page 12, my lord.
Para 8 is the direction of.
You can regularize. Have you given him a copy? Give him a copy.
And if he's agreed of it, he has to finally selling this. People of the pension people given the pension part of it.
You get your instructions, Mr. Mike. Third, Mr. Ramesh, current counsel for the petitioner who submits the order. The directions contained in the order dated 28/02/2018, past date 6/5/00/2017 has not been complied with. Mr. T. Chisti, on the other hand, submits that as per information received from the Department of School Education, the pension of the petitioner has been regularized by the Director of Pension by the letter number so and so dated 18/8/2020. So a copy of the communication is placed before the court, which is kept as a part of the case report. Mr. Sheikh prays for 2 weeks further time to obtain complete his instructions in respect of the same communication place, and a copy of which was furnished to Mr. Sheikh in the court. Is after 2 weeks. Well,
Item 14.
And 40 was the we have already issued a complaint for the.
some appeal was pending.
They are very big pictures. They have funded petition is minor, only 2 issues are involved minor. The non-disclosure of the departmental appeal, minor filed by the late petitioner, as well as minor non-responsive applying of the pensionary benefit. Because last month, minor, I have received the communication from my colleague, whereby it appears minor that the departmental appeal has been disposed of. But my client has not received any information with regard to disposal of that appeal. Consequently, finally granting 1 week time, minor.
Mr. R. Babujari, learned counsel for the petitioner, submits that by order dated 2001-2020, passed in WPC 207 of 2020. This court has disposed of the order directing the appellate authority to dispose of the appeal preferred by the petitioner within a period of 3 months. And if the appeal is not entertained by the appellate authority, the same cannot have any effect on the release of retirement benefits to the petitioner. And the retirement benefits will be released to the petitioner subject to refund of rupees 81,569 of as directed in the order of penalty.
My lord.
This court further directed that in the event of the appeal being allowed, there may not be a necessity to refund any amount. So today, the matter is called Mr. K. Gogoi, Learned Standing Council Higher Education, has placed a copy of the speaking order number so and so dated 27th April 2023, whereby the appeal preferred by the appellant petitioner was rejected. Stop. He's placed a copy of this order before the court, which is kept on the case report. In the case record, Mr. Borpuzari submits that he has no instructions on this order, which has been passed, and therefore prays for 2 weeks time to complete his instructions. This after 2 weeks. 2 weeks, even late.
Object to my lord, convenience, my lord.
13th September.
13,
13th September.
30 or 13? 13, 13.
My lord. And so,
Item 41.
We have already considered the order. Direction not to place the case of the appeal to the petitioner before the state level committee to take of place, and his case was rejected by the to be committee of it.
Now, in case for the petitioner on call, it is submitted by Mr. Chisti that the directions contained in the order dated 31/8/2021 in WPC 3870/2021 has been complied with. So, by the order dated 31/8/2021, this court had directed as under para 4 relating. As per the order number so and so dated 31st of March 2022, which is placed before the court by Mr. Chisti appearing with the respondents, it is seen that in compliance of the directions of this court by the order number so and so passing the basis so and so the appeal petition, the petitioner was placed before the SLSC meeting, and after examining the documents, it was decided not to propose a name of the petitioner for provincialization as service of his service under the Act of 2017 for non-fulfillment criteria. So for non-fulfillment of the criteria. So in view of such order being passed, the taking on record the submissions made and also taking note of the order passed by the order number so and so dated 31st of March 2022. This court is of the view that the directions of the court by the order dated so and so passing WPC so and so stands complied with. And accordingly, contempt petition can be closed. So although none appears for the petition,
And
the
for 1, 2, and 3.
order passed. The contempt petition stands closed. Mr. Chisti appears for respondents 1, 2, and 3.
Okay. 42. 42 also we have complied with public complaint for that. Here, look, the direction was to the director of any jurisdiction to consider the claim of the petitioner, para 6 of the order of it, and the pass a revision order. Accordingly, look, the director issued an order 26 August 2022 of it. And in the conclusion of in the view of the above text and circumstances as per inquiry report, the name of the petitioner Sahadan Ali has recommended by the DSC Gwalpara as additional teacher for continuation of service in the board. Bapur Vita Girls Indian Cut as the enrollment provision does not justify the additional teacher for Bapur Vita Girls MEM. The SLC as well as joint committee did not recommend the name of petitioner Sahadan Ali for consideration of service under the provision of the Provision Consideration Act 2017. And the service of the petitioner Sahadan Ali cannot be considered in Bapur Vita Girls MEM under Consideration Act. Now he has a challenge, he agreed by this order, that we have to challenge this order.
What is the direction?
Direction of the
Claim
para 6.
for provincialization
Yes,
as a language teacher.
yes. Director to consider a claim of petition and pass a revision order of it. Thereon. That's 9 matter. In doing so, director shall examine the record as to when the petitioner was appointed and for what subject, and if the record reveals the petitioner is a language teacher, the school concerned from the year 1993, if otherwise eligible, the director pass a revision order. So director, after verifying all the records of it, pass the revision order dated 26/8/2022, whereby he rejected because he was recommended for additional teacher. And as per the enrollment notice, that appointment of additional teacher does not justify the fee as per the 2013 Act, and hence his case of not being rejected, but he was not recommended.
What do you say?
My lord. William, my name was recommended as social studies teacher. Instead of language teacher, it was not given to my lord. Now the finding is given, my lord. And my name was recommended as my lord. This my lord indirectly statement.
Come to para 6 on the judgments. You made a claim for provincialization as a language teacher. Now. You were recommended by the DSC. What is DSC?
District Scrutiny Committee.
District Scrutiny.
In the order itself, reflected the additional teacher of the first place. In the findings.
Wrong finding.
Where, page number?
No,
Para?
in my.
In your instruction.
Yeah, in the first page, in the findings, or there a column, Sahadan Ali, serial number 5. Indeed, teacher, this date of the so recommended as additional teacher. That is a remark.
So what was directed by the court?
Directed by the court in para 6 of page 9. In view of the above, we dispose of the writ petition directing the director of the education Assam to consider the claim of the petitioner for provincialization as language teacher in Bapur Vita Girls MB Madrasa.
Now is Hindi not a language?
Hindi is a language, but clearly Assamese and other pieces also there that are associated. And for additional teacher, their enrollment has to be more than notice.
But legal teacher is still lying in this. Court of Investigator has not processed my lord. It not approved the honorable court, my lord, who directed my lord to consider my case, my lord. Having litigation, my lord, I got recommended as well as solicitation. And that was my grievance, my lord. That has been depicted in the order. Well, passing this order, my lord, the director has given me wrong findings.
Maybe the tenant is not.
Which wrong finding?
My lord, he has stated that my name was recommended as my lord, this is not correct, my lord. My name was recommended as Socialist teacher, my lord,
Huh?
by DLC.
What teacher?
Socialist teacher.
Where is that DLC?
My
Report?
lord, it is, my lord,
Not here in the content.
No,
it is in my lord, very-
content is only for the director or
my lord,
director.
it is reflected in the.
No. Director was merely not directed to dispose of.
Yeah.
Kindly come to para 6. Director was directed to consider the claim
Yes.
for provincialization as a language teacher. And pass a reasoned order.
Yeah.
Now
And also examine the records,
Ah.
when the petition was appointed. and
appointed
also.
for the purposes of considering his claim for provincialization as a language teacher.
Yes.
Now,
And-
director says he was never recommended as a language teacher, he was recommended as an additional teacher.
Additional teacher by the district scrutiny committee, the first additional teacher, there are two recommendation losses. Next day losses, according to the DSC, Guwahati recommended the mine is the 9618 as a social studies losses, designation social studies, but recommendation is not given here losses. Ultimately, government eliminated department has constituted a joint committee to examine the proposal of the consideration of particular petition of losses.
Come to the last conclusion, it says your name was never recommended subsequently by SL, SC and joint committee.
My lord, my lord, definition, I have annexed my lord, given money of the district, my lord. In that, my lord, recommendation, my name was recommended as my lord. Socialist teacher, my lord.
Now
Subsequently, my lord,
subsequently,
my lord, I don't know what to go home, please, my lord. One of time, given my lord, I will.
But that is because social studies, the two persons, two names were recommended.
let him
That is
give
why.
the instructions.
That is why he was shown as an additional teacher.
Third learned counsels for the parties, Mr. Chisti. You're Mr. J. Islam for the petitioner, Mr. Chisti learned counsel for the respondents.
Yes, it's only one. Sadhana Solar.
So respondent submits that by order dated 26th of August 2022. The who considered the director,
The director has passed the order and director whether it's on report, but with the SLC has rejected.
director has considered the claim of the petitioner as per the directions of the court. ID order dated so and so passed in WPC so and so. And upon due consideration of the facts and circumstances, the claim of the petitioner was rejected. Mr. Chisti has produced a copy of this order. Number so and so dated 26th of August 2022. A copy of the said order has been kept in the case record. And a copy has also been served by the respondent counsel to the petitioner. Mr. J. Islam, the counsel to the petitioner, prays for weeks, 1 week's time to complete his instructions. Placed accordingly after 1 week.
Item 43.
Page number 9 is the order. Relevant page is not clear. So that is clear. Here, okay, though I am not appearing notice for the respondent, I have to submit it. Here, the petitioner some Mr. Dr. Vijay was included as a party respondent. But for quite long time, as she is suffering from cancer, she is not in service locate. And that's why in professional document and period service is yet to be served, is not yet completed locate. So may I present, let the petitioner use the new cabinet secretary, that will speed up the matter also locate. Otherwise,
Mr. Rajiv Learned Counsel for the petitioner, placeholder is granted 2 weeks time to implement the present incumbent in the post of director secretary. Secretary to the government of Assam. Department of Elementary Education. Mr. T. Chisti appears for the
no, I
respondent number 1 list after 2 weeks.
Items 44 and 45.
My lord, the institution was displaced due to default of lawyer. Earlier lawyer the Miss Inha. She was suffering from illness for a long time. She, when became anything better condition, she filed a condonation petition, wherein she stated that there is delay of 3 days only, whereas there was delay of 190 days. The calculation was wrong. Then we have withdrawn that IA. Then we find another IA stating that there are 192 days of delay. After deduction of the honorable Supreme Court order and issue of the petition, then regarding for a COVID period. The honorable court held that there are no proper results have been shown. So we were asked, we were given liberty to show cause. So thereafter we filed an additional affidavit on 25th July. Can you see, here is everything. Here what you would see, we have annexed the earlier petition also. That may be seen on page 23, the earlier prayer. Page 23, the additional affidavit. That the applicant makes to submit that as and when the interlocutory application was filed, that there is a delay of 3 days. Actually, there should have been 192 days. So we have filed the IA, that is 278. That it was the view of the other parties that proper grounds are not stated. So we have filed in details everything, stating the order of the Honorable Supreme Court also. And we have also brought some citations of
Delay for restoration.
restoration. Very minor matter.
What is the ground for the delay?
Ground for delay is by the first that the case of dismissal that was not known to the petitioner. Because the lawyer was suffering from illness, this is in her condition is still not so good at all. Sometimes she comes, so but she filed a petition for restoration, but the calculation was wrong 3 days. Then we filed a petition that 190 days, we withdrawn that petition and filed an IA. It was the view of the other party, there was no reason. So reasons we have explained in details in our affidavit, that is 25th July 2020. The results may be shown that lordship, this is the main reason is the order of the Honorable Supreme Court. That is the order, can you see? And this should be rejected. Honorable Supreme Court's order, first is Leclerc application number 21/2022. And 6/5/2021. So motor petition 3 of 20. So all this time deduction would be, if deductions are counted, then it becomes 192 days only. So para 3 of the say order of the Honorable Supreme Court, phase 3 para 4.
allow the present application by restoring the order that is so and so passed by this honorable court in Somoto Institution number so and so. And allow the present application by restoring the order.
Any objections by the respondents?
They have not filed any objection.
What should be different? What my level friend is submitting.
Now we have citation because large number of citation. Yes.
Large number of citations worship will cover only if there is an explanation. Now, here is the case here, Supreme Court's order was in view of the COVID, the delay is after that. And
But you file your objection if you want.
worship, I will have, that's.
Well, you file your objection if you have objections.
Worship, if I, if that means.
You don't know.
Put on record, worship, I will file my.
Last year, my lord, 30
Yes,
after the
worship
last
will see his petition, there is no explanation.
What is the issue in the writ petition?
issue that if some centers were allocated by the KK Henry Open University. Some centers were allocated for going to take admission of the students and to take fees, etc. And that was done, the investigation we have made, following a sudden that was closed. That order was cancelled without decision.
You are, who are you?
We are the institutional head,
Of which institution? These centers?
centers, yes. So our centers were allocated for the purpose of getting admitted the students for undergoing the courses of KK Henry Open University. So
That was cancelled by KK Handling only.
that was cancelled without issuing any notice suddenly. So
What notice is required?
so whether this is a very pathetic matter that this. When there are.
Let them file their objections. They have some objections.
They have objection, they have got notice, many persons have got notice, not earlier, but they have not yet filed. They are only killing time till the 31st July, because that is the last day for us.
31st
31st July is the last day
July of,
for 2023.
it's already,
That's all,
it's already gone.
31st, sorry, 31st August.
31st August.
Yes, that's why we look, they are killing time. It is my thinking, because otherwise, lordship in our delay matter should be considered liberally, and that too when the lawyer was absent. Party has no fault at all. So many citations I have given, my lord. Kindly see the citations I have given, and I have also brought the book.
See, we are on the issue of whether there is anything live to be decided in the writ petition. What is the point in restoring a matter if there is nothing more to be decided? That is the reason why we are asking.
Yes, my lord, condemnation is allowed.
Condonation is allowed is okay, but then to bring up a matter which is already, there's hardly anything to be heard. Why take the trouble of reviving it again?
But we want that before 31st August, some hearings should take place and case should be decided. Otherwise, what will be, we will suffer.
Where is the writ petition filed? Asim?
Writ petition was filed by Lord, on 10/6/2020. That was filed in 16. It was filed as per affidavit, it was filed on 16th September 2016. And it was dismissed due to default of lawyer. That was on 26/8/20. So we have annexed 11/3/2020, it was dismissed. Thereafter, I was filed on 26/8/22. But they say that there is no proper explanation, we have given explanation. So it is a very minor thing. But you will not discuss very liberally, it should be granted more so when the lawyer is absent. And that lawyer, my lord, she is heavily suffering. Till today, she comes to court with help of this speaker. Sometimes it comes, sometimes it does not come. Our solution is this, well, consultation may be allowed and the case may kindly be restored, and thereafter let the matter be heard before 31st March. That is the last day. Otherwise, we have arranged so many inspections for undergoing, getting admission.
What is this coordination committee?
Coordination committee is the committee of all those private and non-affiliated study centers which were granted to take study to use a study center by the KK Henry.
These study centers are established by whom?
Established by the
Where is the order permitting the study centers to be opened?
yes, that is the. Page 19 of the report. The center in charge and principal, KK so-and-so study center, so-and-so. Approval of study center. I am directed to inform that the authority of so-and-so is pleased to approve your request for setting up of a study center of this university in your institute. So this is the order, and suddenly it was cancelled. It was cancelled on
Where is the UGC,
plus 27.
UGC circular? 5th of July 2016,
It was 22, plus 20.
the page 22 is the circular. What does it say?
It says that the registered director Krishnakanda, Henry Open University, inference meeting for considering continuation or distribution to offer programs through distance mode ticketing. So.
What were you imparting? What course?
Different courses under the one university. Many students could not come to university and they take admission in those study centers. And they provide the name to the university. And they institution also.
Mr. Dev Chaudhary, you are appearing for the university.
No, I is for the university.
So why did you close all these institutions?
It is as per UGC's direction.
What is the UGC direction?
It was page 22. It's July 2016. May I read it? No, this is the registered university. This is in combination of detailed proposals submitted by the institution and subsequent presentation interaction with the expert committee held at the office. The matter of continuation of recognition was assessed by the expert committee and its recommendations will be approved by UGC as mentioned below. 1. The affiliated programs which ITA are not recommended, which are technical in nature. 2. It is important. Study centers which are in private non-affiliation activity need to be closed within 15 days, failing which the program may be withdrawn. Particularly in this direction, in paragraph 2. All the study centers were directed.
No, which study centers?
Study centers, the undertaking and the.
Kindly come to page 22.
22 paragraph 2.
Paragraph 1.
The affiliated programs which ITA are not recommended, which are technical in nature. Number 2.
So this is these study centers are relating to number 1 or any study center.
It is not related to number 1. Different. The number 1 is related with ITA. The number 2 study centers. The third one, all experts have made some general observations regarding distance education program, which are mentioned and following. The university higher education institutions running the UG, PG diploma certificate course in science subject, which obviously involves practicals, are required to have requisite infrastructure and ensure the conduct of practicals. 2. The institutions have put the list and schedules of practicals on their website and a copy of the same is submitted to UGC. The university institutions need to furnish an affidavit for infrastructure and imparting practical training to the students.
1 minute, Mr. Mahmood, please come to page number 19.
Yes.
What is these 3 courses? BA we can understand. BPP and CCA, what are these?
Page 19.
Annexure 2.
BPP.
No guesses, just get your instructions on what are these courses?
But this is issued by the university. This is issued by university. Now, our plan is this method. They have granted study center on 24/5/2010. On 4/9/2016, they have suddenly closed down the center.
If your study center is in conflict with the UGC norm, they're bound to close it.
But that's what we should know about this. Why? Because we have already taken admission from the students.
Maybe,
We have paid us fees.
but if it is
We
in
have
conflict,
deposited
if it is in conflict,
in conflict maybe, but
then what benefit do you get by being put to notice? How will you,
Lordship, we have taken admission of the students.
you
We have
refund the
also
money?
paid us fees,
You are required to refund the money.
and we have also deposited to university. A portion of the fees have been deposited in university.
Claim from the university, have you claimed?
No, our claim is that only that will be continued because infrastructure we have made for the huge amount. So all of a sudden it is closed.
Mr. Dev Chaudhary, you file your objections. I don't think anything survives in the writ petition. But nevertheless, nobody has objected to the delay.
Delay with the very condemn. Delay with the very condemn.
We can't condone unless we hear the matter. Let them file. No, we see, there is a delay. Writ petition was dismissed, there is a delay. You are now praying for condonation, and we don't want to take a very rigid view.
Yes.
But we have to be at least convinced that yes, there is some material to hear in the writ petition. To revive that writ
The
petition.
UGC has asked them, but.
You don't even know what courses you're offering, number one. Number two, you are the petitioner. Your filing is what is the coordination committee. On what basis have you arrived at that committee? What agreement?
They are the condition to have different studies.
Exactly. So all these different institutions will have different causes of action against the university or the UGC. How can you together sit and make a coordination committee and come before the court?
Representative character they have.
This is not a PIL. If there is a committee, yes, produce some documents to show that all these institutions have got together, authorized you to pursue this litigation. These are questions you'll have to answer before we condone a
So the
delay.
university has created, but they should have involved us that this is that you have the university, so we have to read out. All of a sudden, so this has created problem.
You have remedies against the university for not creating financial difficulties or issues. Heard Mr. M.E. Mahmood, learned counsel for the petitioner, Mr. R.K. Dev Chaudhary, learned counsel appearing for respondent number 1, and Mr. P.J. Fukon appearing for the university, praised for and is granted 2 weeks' time to file their objections if any, in response to the claims made for condonation of delay. Matter stands adjourned for 2 weeks. Let them find something.
Item 48.
Before 31st, let it be on 25th.
But I appeared in the
45.
One of them is of course really for that group of institutions that goes down. I was also part of one of that.
You have given responsibility to the committee.
Yes, but subsequently I filed this petition because this is business and there are some orders to pass later on. So I challenged those and when that case was my case, the UGC signed that agreement. That's not a record. It's not like my reply.
But then it goes beyond 30. He says 31st is the date. All right, 25th, yes.
I've got some difficulty on 25th. Can it be on 28th, 29th?
You file your response by 25th. We'll consider it. You ask your colleague to be present. It's only a question of whether delay should be condoned or not. That's the issue. We are not saying don't be available, but in case of any difficulty, you request one of your colleagues to be present. But your objection must be there. If they have some apprehension that 31st is the last day, then we are bound to hear the matter before that. 26th, yes.
Item number 48.
Let me know. So it is a contest petition. And it was to my lord, I have taken the state, my lord, as per office number 10 and 2023, my lord. Service about the response number 1 is away and response number 2.
Await service report on respondent number 1.
And response number 2 is held.
Petitioner is permitted to take press steps at the correct address of respondent 2.
No, my lord, as the department of the already informed the response number has some health issues, my lord, cancer.
Oh.
And present the secretary is the response number 1, my lord. So response number 2.
It doesn't matter, we await service on respondent 1,
My lord.
just after 2 weeks.
All right.
Cancellation of my claim to 12/4/23. 24. In the meeting 12/4/23. Now they have issued a letter for hearing, that is page 15.
Item 49.
Page 15 is the letter. 2nd of May 2022. Hearing was done on 15/5/22. So after cancellation, they are decided to cancel my provincial because that will form making formalities. I have been asked there. My provincial is not
To be heard by whom?
by the director.
Director. I think, so this is a resurgent case of
After cancellation.
that isolation order is phenomena which was there earlier, cross connection. Committee may decide that's a different issue, but you are not required to be by the committee. Now, what is the earlier order here?
Order I was.
I think you are relying on some orders of the court.